Good morning. My name's Emma King. I'm the CEO of the Victorian Council of Social Service, and it is my absolute pleasure to welcome you here today and to thank you for joining with us. I'd like to begin by acknowledging the traditional owners of the land upon which we all meet today. I'm meeting on the lands of the Wurundjeri people of the Kulin Nation and would like to pay my respects to elders past, present and emerging, and of course to acknowledge that sovereignty was never ceded. I'd like to acknowledge as well any Aboriginal people or Torres Strait Islander people who are with us today. This is the fourth Renters' Rights Rundown event that we've held. Firstly, this was in respect to two different issues that emerged. The first of these was COVID, which, as we know, upended our society, our economy, and really prompted the Victorian government to push through a raft of measures that were designed to keep renters safe and housed during the pandemic. Secondly, Victoria's rental rules, as we know, are due to change on March the 29th, just next week. This is a phenomenal change. It's a result of extraordinary work undertaken by so many in the community sector over a number of years. It's very much years of advocacy from the community sector, and this is going to be the focus of the session that we have today. We know just how important it is that renters know their rights. And we know that for many of you who work in the community sector, you have a very key role to play in terms of supporting people who will exercise their rights and enjoy the benefits of new rental fairness laws. It's exciting to be at this point in time. One of the other things that's fantastic, shortly I'll introduce this session in more detail and work through some of the housekeeping issues that we'll be stepping through today as well. But it's also my absolute pleasure to be introducing Minister Melissa Horne. I think the Minister probably needs no introduction to anyone who is on the line with us today. Since commencing in the role of the Minister for Consumer Affairs alongside the raft of other responsibilities that she has, the Minister has shown a genuine commitment to really having a very deep knowledge of the issues that impact upon everyone in the rental sector, of all of the many hundreds of thousands of Victorians who rent. She's also shown a very deep commitment towards engaging with stakeholders and continually working with us to achieve the very best outcome for all renters in Victoria as well. So I would like to acknowledge that as well and to say how excited we are to have her join with us today. We know that she is incredibly busy and it's fantastic that she's been able to make the time for us this morning. So it's my absolute pleasure to welcome you, Minister Horne, and to thank you for joining with us. And I'll hand over to her now. Thank you. And I'm just seeing, apparently the Minister, sorry, nothing like being live, the Minister can't get into the call. So I might ask one of our team to jump on and assist her. Bear with me for 2 seconds. I am just going to message her back to let her know that we're following up now. And in the meanwhile, I'm going to talk to you a little bit. I might jump into some of the housekeeping things that I was going to step into later while we're waiting for the Minister to jump into the call. We've got a fantastic morning ahead of us today. Not only do we get to hear from the Minister, we have a session that's going to be run by Ben Cording from Tenants Victoria, and which will be followed by a Q&A with both Ben and also Catherine Bannon from the Victorian Government, from the Department of Justice and Community Safety. Ben is going to step us through all of the elements of the new rental fairness laws, and there are many. So it's fantastic having someone of Ben's expertise, and also I think having someone from Tenants Victoria who've done the most tremendous job in terms of making sure that again, renters know their rights and being able to step through the complexity of many of the changes that are coming and the benefits that are coming as well. After we have that session, we'll have a short break, and then we'll have Ian Goff from the Council for Homeless Persons, who's going to host an interactive panel discussion with a range of experts, which will be fantastic. So we really do have the most fantastic morning available for you. And I think the chance to get across all of the different elements of the new rental laws that are coming into being today as well. I want to mention too that we have allowed plenty of time to allow for audience questions. We've had really great feedback from the rental fairness sessions that we've run around. One of the really important components is not just filling the sessions with presentations, but making sure you get the opportunity to hear information from the experts, but allow plenty of opportunity to have your questions answered. We know how important that is, and I can assure you we've allowed plenty of time for that today. If we get inundated by questions, which I know has happened before, and it's a very good problem to have, I promise you we will get back to you with answers to your questions. But please also be aware as you post questions in the Slido, which will be up before your screen shortly, when you pose your questions, if we have a number of questions that are similar, what we'll do is sort of combine those together to make sure that we're getting through as many questions as we possibly can. But we know that that's one of the most important things out of the sessions that we run today, and the other sessions we've run and we'll run in future as well. I'll just step through in terms of while we're waiting for the Q&A session, how that's going to work. And I'll touch on this again later as we head into the session. You'll see a Slido box underneath the video as others are presenting. The questions, as I said, will be moderated, as some will be, similar. And while the panel won't be able to answer questions about individuals or specific individual circumstances, we will get through as many questions as we possibly can. So I would like to, perhaps to take this time, a bit of extra time really, to acknowledge the work of Tenants Victoria. Tenants Victoria have just been instrumental in terms of assisting renters and understanding their rights, particularly during the COVID time. We know that this has been an incredible stressful time for pretty much everyone across our entire community, but particularly for those who are really in fear of losing their home and losing somewhere safe and secure to live. And Tenants Victoria is instrumental in doing that. So I would like to take this opportunity to thank Tenants Victoria, and we're so happy that they're able to join with us today. And it's our pleasure to do a number of different events together as well. I would be remiss if I didn't acknowledge a few of our other partners as well. Justice Connect, of course, as many of you will be aware, have just been so instrumental in the reforms that have been delivered. It's fantastic to have Samantha from Justice Connect, who is also joining with us today. We've got our other key partners, the Council for Homeless Persons, or CHP, which many of you will have had the joy of working with before. We've got Ian with us from CHP today, but I would like to acknowledge Ian and the fantastic team led by Jenny Smith at CHP. We've got Launch Housing, we've got Neil from Launch Housing joining us today, as well as Samantha, as I mentioned, from Justice Connect. So we're just waiting for the Minister to jump in. I'm sure she's not very far away. I know that's all trying to happen, so bear with me as I'm just having a quick look at my texts. So I'll take it that we're very close to doing that. Oh, here, we've got the Minister now. I can see her online. Minister, I'll give you a quick moment to make sure that you are tuned in. By way of introduction, I did want to, while you're on the screen as well, I did just want to acknowledge the incredible commitment that you've shown towards rental rights and really, since starting in the portfolio of Consumer Affairs, working to really have a very deep knowledge of the issues that are important to and impact on renters, and the incredible commitment you've shown to working with stakeholders, including VCOS, which has been it's very much valued by us. So I really want to call that out at the beginning. We know that you are incredibly busy. You've clearly had to manage a few technical issues as well today. So thank you for hanging with us, and thank you very much for being here. And it's now my absolute pleasure to hand over to you. So please join with me in welcoming and thanking Minister Horn for spending time with us today. Thank you, Minister.
Thank you very much, Emma. And hopefully my IT holds up. I'm not entirely sure. I don't know if or I suspect it's possibly me. But before I start, I'd like to acknowledge the traditional owners of the land on which we meet and pay my respects to elders past, present and emerging. I'd also like to acknowledge Emma King, and I think since I've been in this portfolio, we've managed to build a really solid relationship where I understand many of the issues that the sector faces, and also we've been able to work through that in an incredibly constrained way. Over the last 12 months, without a doubt, it has been one of the most challenging times that I think any of us will face in our lifetimes, touch wood. And during this time, the introduction of temporary rental measures, ensuring that Victorian renters could stay in their homes during the pandemic, is something that I'm incredibly proud to have had carriage of. These are due to end on the 28th of March, and a new package of reforms are commencing straight after. And it's really good to be able to see the sector coming together to be able to prepare for this transition. Given that more than 1 in 4 Victorians rent, these new reforms are about fundamental fairness. And I think without the pandemic, they would have been greeted with such accolade by the renting community. But I do appreciate that as we're going into a state of having come out of the pandemic and there's job seeker ending and there's so much uncertainty, being able to make sure that we allow that transition and to look up and be responsive to what's occurring is absolutely top of mind to me. Because fundamentally, this is about making sure that renters have the right to safe, secure and affordable accommodation, regardless of what sort of room that they're renting, be it private rentals, caravans and residential parks, as well as rooming houses. So as I said, on the 29th of March, what we will have is more than 130 rental reforms coming into effect. And it is the most comprehensive rental laws that has ever been seen in this state. We've listened to the renters, advocates and other stakeholders and landed on changes that will ensure greater accountability and clarity for renters and landlords. And they are ultimately designed to protect the most vulnerable renters. About a third of tenants are long-term renters, having rented continuously over a decade. Many are older Victorians who are on fixed incomes or families with young children, and many have been priced out of what remains a fiercely competitive housing market. And like all Victorians, they deserve stability, certainty, respect, and somewhere really to call home. These new laws include a ban on rental bidding, as well as a prohibition on rental providers asking inappropriate information in a rental application, which is bond history. And first-time buyers will need to ensure that the following are included in a property. And I've got to say, when I walked into this portfolio, knowing that these things weren't a basic right sort of blew my head away a bit. But things like, a working stove and a sink in the kitchen. All external entry doors are fitted with a lock. Rooms being free of mould. A vermin-proof rubbish bin. A toilet in good working order. A reasonable supply of hot and cold water. And window coverings to ensure privacy in bedrooms and the main living area. In addition, renters will no longer have to ask permission to attach child safety devices, replace curtains or install picture hooks. They can now have a herb garden, security fly screens, made it easier to keep pets. It's a win for both animals and the people who love them. Suffice to say, the ability to have a dog or a pet or a cat pottering around a house gave considerable solace to thousands of Victorians during our long lockdown. And for people who don't rent, these may seem like really trifling issues, but for too long, renters have been denied these basic rights, particularly in regards to making their property safe for young children. And for too long, been at the mercy of certain unscrupulous landlords who have cut corners and denied them some of their most basic rights. I appreciate, as I mentioned, there is considerable concern about the imminent expiry of the eviction moratorium. However, I am confident that the commencement of the Residential Tenancies Amendment Act immediately after the eviction moratorium on the 29th provides for significant protection from the frequent rent increases and increases security for renters of tenure for renters. Yesterday, we finalised transitional regulations winding up the Residential Tenancies Dispute Resolution Scheme and facilitating the transition out of the eviction moratorium and into the new rental reforms. These transition regulations will be supported by detailed operational arrangements, and further information will be available on the Consumer Affairs website. When it comes to renters' right, our previous regulatory settings were, as I said, clearly antiquated and had been in place since 1997, and our housing market has changed beyond recognition. We need to have an adaptive and flexible system that supports and protects people who rent, but also to addresses the trend to people owning multiple investment properties. And I believe these laws really reflect that. And they're laws that very much align to the values of this government, values of decency and fairness and generational reform. And I'm to have courage over this long overdue reform, and thank you very much for having me today. And I'm sorry about the scratchiness of my IT.
Thank you very much, Minister. If I can also pass on my sincere thanks to you. There's nothing like dealing with challenging circumstances around us. We all get it. It happens to all of us. And the reality with these live events is we've all negotiated technological challenges. So thank you very much, not only for bearing with us this morning, we really appreciate it, but for the incredible work that you do. And actually I think the commitment that you've shown and clearly demonstrated towards really improving the rights of renters and all of the aspects that you picked up in your speech that really talk to the challenges that renters have had that were already there, but then were magnified during COVID as well. So your commitment to this portfolio is phenomenal, and we thank you, and we very much look forward to continuing to work with you. So thank you for making the time to spend with us today. It's much appreciated. Have a wonderful rest of your day, and we look forward to seeing you soon. Thank you. In terms of the rest of our session now, as I mentioned earlier, the rest of the day is broken, or the rest of the morning is broken into two key sessions. Our first key session is with Ben Cording from Tenants Victoria. He'll take us through the changes, and I'll introduce him in a moment, and then followed by a Q&A with Catherine Bannon from the Department of Justice and Community Safety. We'll have a short break before we have a session with Ian Goff from CHP, who's going to have a fantastic interactive panel discussion with colleagues including Damien Patterson from CHP, Helen Matthews from the CHP Peer Education and Support Program, Launch Housing's Neil Parker, and Samantha Sarawan from Justice Connect. This session also, as I mentioned earlier, has plenty of time allocated for audience questions. As I mentioned earlier as well, in terms of the Q&A sessions today, you can submit a question at any time through the Slido box that sits underneath this video. The questions will be moderated, as I mentioned, because we imagine many of you will be asking about similar topics, which is entirely understandable. And please do note the panel won't be able to answer questions about specific or individual sort of specific circumstances as well. We will get through as many questions as we possibly can, but we will take any unanswered questions on notice and get back to you as well. We know that's been such an important part of the sessions that we've run on these lines. We will also ask you to do a quick exit survey at the very end of today's session. It does help shape future sessions that we run, and it's really important to know how you found this morning, and we're constantly looking to improve and to get your feedback as well. So be very much appreciated if you could do that. And before I hand over to Ben, again, I'd like to take this opportunity to thank Tenants Victoria. I know I mentioned this earlier, but Tenants Victoria have been our partners for a number of these sessions. In addition to running their own direct outreach and engagement programs, it is always fantastic to work with Tenants Victoria, and again, it is our pleasure to do so today. So Ben, you've got the huge task today. You're providing an overview of the 130 changes that are taking place. So I'm going to hand over to you, and then I will join you again for a Q&A session afterwards. So thank you, Ben.
Wonderful. Thanks, Emma. I really appreciate it. All right. Well, hello, everyone. My name is Ben. I'm the lead education officer. I think that's my new title. I used to be the principal of Tenants Victoria Legal Service for probably about 7 years, and I've been there for almost 10, so I'm getting old. So today is the Renters Rundown. Hope you've had your coffee because we may be running. There'll be a lot of content there. I try to produce slides that are really going to be more of a resource, so I'm not going to be reading through them. We're going to try and get through quite a lot of material. Some of it's really simple, so you don't have to be too overwhelmed. Some of it is actually quite complicated. The biggest take home you can have today is that we run an organizational advice line. If you need, you can totally call us. We're funded to do it. We're happy to hear. There's no shortage of demand already. That was pre-COVID. Then during COVID, you can imagine the demand. And then I think now a lot of things will be coming out of the woodwork per se. So I hope you've had your coffee. I'm looking at the interpreter. Thank you for interpreting. Tell me if I'm going too fast, okay? All right, let's see how we go. All right, so hopefully first technical difficulty. We're trying the slidey thing. Not sure if that's not enabled. Let me just try. Oh, there we go. Let's just see if we can get all of this working. Okay. Yep, I might need to get someone to check that slide machine or do it for me. All right, next slide if we can do that. Not sure why that's going on. Yep. So obviously I want to acknowledge the elders as well, traditional custodians of the land. I'm on Wurundjeri land. I want to acknowledge connection to land, sea and community, respect our elders, Murrindindi as well, particularly for region and the Kulin Nation. So yeah, if anyone Aboriginal people are here today, it's such an important journey to be on and continue to be on and be very honest and candid. So let's see if we can get this tech to work a little bit better. No, still not having any luck. All right, yep. So just with these slides, they're not substitute as legal advice. You can give us a call if you need to. So just trying to reload this clicker and see if I can get my clicker to work. No, I'm going to have to rely on someone manually. All right, so the hyperlinks throughout the presentation won't work until probably maybe next week or the week after, and then they'll update. We usually use a website which is called Auslit. It's not the formal Vic legislation website, but that should be fine. All right, next slide. Okay, so there's a lot of terminology and acronyms that we use within these presentations. Most common one you'll see, so next slide for this as well, will be that there's a changeover from landlord to rental provider, so they're now known as residential rental providers, and then also tenants will now be called renters. So if you forgive me for interchangeably using them throughout the session, hopefully you'll forgive me. All right, so there's family violence, personal violence. They're not exactly the same thing, so they both have intervention orders associated with them. Breach of duty notice, notice to rental provider used to be called the notice to landlord. They're forms that you find on the Consumer Affairs website, as you do with the notice of rent increase. There's called RSA, which is not responsible service of alcohol in this context. It's called the rent special account, and that's where people that have got repair issues and a landlord that's not doing what they should actually pay your rent to VCAT, so the landlord doesn't get any money until they do what they should. And then also probably about 18 months ago, we inherited as well the specialist disability accommodation. So that's now within the Residential Tenancy Act. That used to sit in the Disability Act. Obviously very welcome to have it. You may come across them. You can actually have a tenancy in an SDA accommodation. So just check if your client has got significant needs around that, if there's a disability and they've been identified as being eligible in the NDIS for SDA. So any questions around that can try and tackle that as well. All right, next slide, please. Okay, and again. Okay, so as the Minister had mentioned, so the big take home that I could also give to everyone today is that the RTDRS, which is the rent sort of dispute resolution around rent arrears, where you can possibly even get a rent reduction, it may even be retrospective. It's open until the 28th at 12 a.m. or 11:59 p.m. People can still get in. So if you come across any clients in this week that go, hey, I've just got so much rent arrears and I can't do anything, get them to apply to CAV. The transitional provisions, which I'm sure there'll be many questions around, essentially will say, well, look, you can still get the benefit of the emergency provisions if you, but that will be now dealt with by VCAT. So it'll get pushed across to VCAT, but that's certainly going to be advantageous if people haven't done that already. The rent relief grant, which is money you can get up to $3,000, that will remain sort of available. That's sort of a wind down. I don't think it'll be the same shut off, but that might be sort of a back end exceptional circumstances thing. We'll see what happens there. Okay. Next slide again, if we can, please. And okay, yep, next slide again. Sorry about this, people. So the transitional provisions, there's 3 links there. There to the actual regulations, as the Minister was saying, were just published yesterday. They're fairly technical, but I think the large summary is that the any termination order. So during the COVID scheme, there was sort of this idea you could get a termination order and then a possession order as well. They were separated into 2 stages. Anyone with a termination order in the new framework, that'll be treated as being a notice to vacate, and we'll just have to see how that goes from case to case. So if you get someone that's got a termination order, then definitely I would suggest giving us a call, and hopefully that'll be of assistance in sort of resolving those sort of issues. So we do take referrals. Our capacity is limited. And that's going to be one of the big challenges of working together with community professionals about who can do what. People can attend in a support capacity. If you've never done that before, it's actually a really good experience for you in your capacity to know exactly what happens in the hearings. Most VCAT hearings are now done on the phone. If we can now skip to slide 29, if the transitional provision sections have not been cut out of that, if that's okay. Yep, all right, so let's talk about eviction. That's probably the thing that's on everyone's mind. Next slide, please. Okay, so one of the big changes that happen with eviction is that the no reason notice to vacate is gone. Yay! So in sign language, cheering, yeah. And that's a huge thing. That means that landlords can no longer just evict someone without explaining why they're doing it. The only exception to that is that there's still an end of fixed term tenancy notice. So you kind of have almost like a dating period for your first year or whatever your fixed term might be. And then after that, they can no longer give a no reason or an end of fixed term. So it only applies to the initial. And then after that, they've got to say, I'm selling, I'm moving, or there's some sort of conflict. It might be a fault-based notice. And then, you go from there. So that's a huge change in accountability of people feeling afraid. The no reason notice being gone, used to be able to challenge that for retaliation. So you ask for your oven to be fixed, and then all of a sudden they say, oh, here's a no reason notice to vacate. That still applies to the end of fixed term, the initial one. So that's certainly a good step there. All right, next slide, please. All right, so this is what the notice to vacate will look like in rough form. Why am I showing you forms? Pretty boring. One of the biggest misconceptions for renters is that they think, oh my goodness, there's a termination date. I have to be out by that date. That is not correct. You can stay beyond the termination date, and what that does is that it forces the rental provider to take them off to VCAT, and they can challenge. And as what Sam will talk about, and I'll cover a little bit briefly, is that the rental provider has to prove their ground, saying this is why I'm kicking you out, but they also have to show that it's reasonable and proportionate. So the tribunal, like if there's someone that's really, really vulnerable, there's now this thing called the reasonable and proportionate test. So this form now provides much more information. Now, a lot of people just get shocked and go notice to vacate and flick it, but it is much better than it used to be, and there's been a lot of work done on it, so we're very grateful for that. Yep, so if we can just skip through those next two and to the next slide. Yep, the next one. All right, so this is a really, back one. This is a really, really important just understanding. If you haven't dealt with evictions before, there's a number of steps to it. The first one is you get this thing called a notice to vacate. And that notice to vacate is what I just showed you. It will say, this is why I'm trying to kick you out. And then it'll say, this is a date I'd like you to be out, but actually you don't have to be out by that date. If you don't move out and the renter remains in the property, there's a VCAT hearing. At the VCAT hearing, there's a lot of discussion in terms of what are your grounds, is it reasonable and proportionate? At the end of the day, there's probably two main things that can happen. One is what's called a possession order, and that gets granted saying, yep, sorry, the tenancy is going to be over. At that point, you can actually ask for a bit more time. The slides have got some information about asking for more time, but that has to be done in the hearing. The other thing is that it can be dismissed for technical reasons, or it can be refused for other grounds. Maybe it's not reasonable and proportionate. If the possession order is granted, there's a warrant. It's not criminal in nature, it's just a bit of paper, and that's used by the police. Only the police can evict someone, and that's given a 14-day window. It could be on the first day of the 14, it could be on the last day of those 14 days, but the police are the ones that will do the execution. Sounds a bit fatal. If the warrant is not yet executed, what that actually means is that if someone didn't attend to their hearing, say for example they missed their possession order hearing, you can actually ask for a review, and that's really, really time critical. You can lodge that review with VCAT. The information is on their website, the links are in the slides here as well, and that can actually allow someone to go back that missed their hearing. So a lot of clients that go, I'm too scared, I didn't go, or in this case I didn't dial in, or I didn't answer the phone, or I didn't know what was going on. That's probably one of the most fundamental things to try and prevent eviction. So there's plenty of information around it, but if you hear someone say, I missed my hearing, and the police left a card in the door or something like that, or I know I'm about to be evicted, act very, very quickly. So straight away to Org Advice Line for us, to Justice Connect, whatever you can do. And it's not a complicated application. It's just saying, I missed my hearing, please. And VCAT should tell the police, don't execute the warrant. We've got an application to reopen or review. Same language, different things. All right, next slide, please. Okay, so most of that framework hasn't changed too much. So what we can see there is that there's a change in terms of the minimum period. So largely in the COVID framework, the notice to vacate stuff sort of went out the door, and there's just sort of straight applications to VCAT. What we see now is that we've gone back to the old framework. It's notice to vacate the minimum period. So it might be a 60-day notice. You've got to get that minimum period. And they've got to have statements saying, this is why I'm kicking you out. It can't just be repeating the act. It's got to have a bit of detail in there. There's now a requirement with some of the notices to vacate to make sure that they attach documentary evidence. And that's a really new and important thing. So they might say, I'm doing repairs and renovations, and actually have to provide certain documentation. The requirements of that additional documentation are not in the act, and they're not in the regulations. publications, so don't look for them. They'll be actually published on the CAV website, so just keep an eye out for that. We don't know what the content of that is yet. And the minimum times as provided for in those sections are also important. So you've got some service issues. If you've got a notice to vacate, it's a really good opportunity to call for advice, just to check, because again, there's technical wins that you can make, and if you win those technical arguments, then the tribunal is actually forced to dismiss the application. So that's really helpful. All right, next one. Oh, yep, sure, will do. No worries. Okay, so this is just a table. The table here has got a parallel section. So even though you'll see a lot of strange sections now, if you've dealt a little bit in the legislation, they're just changed over in name. They've just pulled some parts out and relabeled them. Some of those sections there, you can hyperlink them and they'll be active in probably about a week or two. Okay, next slide. And again. And again. Okay. So the end of fixed term notices to vacate. So this one we've sort of discussed a little bit. It used to be, it had to be the last day of the tenancy. Now it can be a date on or after. So just be mindful of that as a minor change. That's fine. We'll go to the next one. Okay, so this is an example. So if you get a client and they've got a end of fixed term notice to vacate. So we've got Ling, she moved in 12 months and then, you know, she might ask for the oven to be fixed, for example, and then all of a sudden on the 2nd of February, she gets an end of fixed term notice. There's really three main grounds here. One is that you can show, oh, they didn't give me enough time, or some sort of technical challenge. Another one is that you could say, well, actually, you're trying to kick me out because I asked for my oven to be fixed, or it might be I objected to entry. It can be any right under the Act. And then the last one is this reasonable and proportionate test. So saying, well, look, the tribunal, even though it's an end of fixed term, the tribunal is still actually entitled to ask and say, well, what are you going to do with the property afterwards? You know, what's really the motivator going on here? And if there's no answer to that question, it may beg the inference of going, well, if you're just going to rent it out to someone else, I'm either going to infer that it could be retaliatory, or I'm going to infer that if this person's facing imminent homelessness and you don't really know what you're doing with the property and why you're actually giving the notice, I don't think it's reasonable and proportionate. So that we've never had that before. It's always been that if they can prove the ground, then the person gets evicted. So that's probably the biggest shift in this framework. Okay, next slide, please. Okay, mortgagee notices to vacate. Yep, just the next one. So with the mortgagee notices to vacate, this may pop up as being a significant issue. We don't know the numbers. It used to be a 28-day notice to vacate. It's now a 60-day notice to vacate. The thing that can be a bit scary about the mortgagee notices to vacate, so that's the bank saying, look, and this usually happens when you've got the rental provider defaulting on their mortgage for some reason. The banks essentially are exercising the right to sell the property. They can sell with tenants in possession. It's very, very uncommon. They tend to get a better price with getting vacant possession, and that's one of their duties, to get the best price they can. So sometimes you can get someone from a lawyer just knocking on the door. You can also have someone, you know, saying, I've got a warrant from the Supreme Court. The take home for most people it would be seek advice. As soon as you get a mortgagee notice to vacate, or a conversation from a lawyer, or a letter from a lawyer saying, look, the rental provider's defaulting, we've got orders or getting orders through the Supreme Court, or possibly the county, but it's generally the Supreme Court, straight away seek legal advice. That's probably the take home on that. For anyone that's technically minded, there's a decision down the bottom. All right, let's look at the reasonable and proportionate test in a little bit more detail. Yep, just jump through. Okay, so this is really about the must to may. I enjoy memes. Hopefully none of them are offensive for people. So this is about finding balance. And I think the Minister again addressed this. It's a really hard thing to find balance in all of this, where you've got people's homes and economic interests sort of in conflict from time to time. So it used to be, if you can prove that you're going to move in, that's the end of the story. Now they have this require, even though the law says still they must give it, they can only give it if they're satisfied that it's reasonable and proportionate. And that's where it comes from, Section 330A. All right, so next slide, please. All right, so these are some of the factors that they might look at. One of the challenges that we really don't know is exactly how the reasonable and proportionate test will operate in the case of rent arrears. Will we see VCAT saying, hey, we're not quite sure whether or not we should take into account COVID hardship as being reasonable and proportionate if you owe 10 grand worth of rent? So we'll have to see. There's this idea of palm tree justice. So when we talk about reasonable and proportion, it's not just this idea of going, well, it's reasonable and proportionate, I get to decide what that is. It is a legal test. test. And that means that the hearings are going to take a lot longer. And Sam, I think, will run through about some of the questions you can ask people, some of the information that are really going to help people to advance their position, and for the tribunal to understand that person's experience, their stories, and what risks they're facing. Okay. All right, next slide, please. Okay, so this is just an extract out of the section, so you can actually see, well, what is everyone talking about when they talk about the reasonable and proportionate test? A large amount of these factors are really based on whether there's fault, so whether or not, so these are sort of the fault-based notices, so you've caused a danger, you've caused, damage, the malicious damage has changed from malicious damage, it almost sort of talks about reckless damage now, so it's a slightly lower threshold. And, other factors involved in terms of family violence. Just jump on to the next slide, please. Okay, probably one of the main ones, which I think is really interesting, is whether or not there's any other order or course of action that's reasonably available instead of making the order. And they're talking about making a possession order in this context. In this situation, we've seen VCAT be pretty conservative. They are interpreting this about going, what other orders could VCAT make? And I think this is where so many community professionals are really, really important, because it may be a really hard conversation in terms of someone's gone off their medication. How do you have that conversation of going, look, there seems to be some stuff that's becoming more difficult, and I've seen a notice here. What's the narrative behind that? What supports can we get in place? What can we do to demonstrate that instead of making an order to evict you, that you can give an undertaking or a promise to the tribunal to say you'll do this. Now, it's not specifically within the power of VCAT to do that, but they're certainly going to be open to it. So there is that real balance of what role you play, what role a lawyer might play, and how they work together to come up with what might be not necessarily a fix or a solution, but a plan. So that's certainly something to be mindful of. And there's also another provision there about whether or not the rental provider has in some ways baited or inflamed the issue. Come in front of the house, you owe me rent, and humiliated the person in front of the children and said, and they say, like, well, rack off and get out of my house, and they're not happy with them being there. So yeah, there's also a new notice that you'll see, which is threat and intimidation. We'll see how that plays out. All right, next slide, please. All right, okay, next one. So compliance orders in lieu of possession orders. No reference to anyone that's from Dumb and Dumber, not calling anyone dumb, but it used to be, again, with compliance orders, or with certain types of notices to vacate, like danger or damage, if they prove that was the end of it. Now the tribunal's being given the opportunity to give people these things called compliance orders, and it's kind of like probation, saying, here's an order, you must not do, or you must do this, and if you do, then a notice to vacate can be given to you. So it's actually a new chance. It's kind of a good thing. What we think may be challenging in this space is that it may lower the threshold, so you'll see many more compliance orders. So compliance orders can be quite good. Equally, they can put people on eggshells if it's not a sensible order, so you must not cause unreasonable noise to be emitted from the property. That can be really dangerous if you're in social housing, and that goes on for the rest of your tenancy. It means that you're at risk of getting these notices to vacate. So the reasonable and proportionate test is still there, which is good, but it may cause someone a huge amount of anxiety. We often suggest that if anyone's dealing with a compliance order, that they make sure it's time limited, so it only lasts for 6 months or 12 months, and it's measurable. Makes sense. All right, next slide, please. All right, so that's when a compliance order can be given in lieu or instead of a possession order. So that's certainly a new framework for some of those what are referred to as, behavioural notices to vacate or the like. Yeah. Okay. Next one. Okay, so new notices to vacate. So threat and intimidation. So this is one that we've already seen during the COVID period. There's a few cases there that you can have a look at, and there's a basis where you can say, well, look, I'm entitled to get grumpy, and there's certainly a decision there that Donaldson and Dorr saying, look, getting grumpy is not threat and intimidation. And then there's others where there's just, I'm going to kill you, I'm going to whatever it might be. And so, yeah, that's a 14-day notice. You can challenge them as being retaliatory as well. But yeah, largely speaking, that's one of the ones that I think that we'll see much more than we've ever seen before. The pets legislation has been with us for some time and actually been working really successfully. You'll see that the notice to vacate there is keeping a pet without consent. That's actually pretty misleading. The pets without consent is actually where you've had a pet and VCAT said, no, you can't have the pet, and you kept the pet anyway. Then you get the notice to vacate. If you get busted for having a pet without written consent, there's a process to it which places the onus on the rental provider to say why you can't have the pet. Then part of that framework that allows you to say, well, look, if I don't have consent but I got busted, it's still on the landlord to go to the tribunal and still prove that it's not reasonable for you to have that pet. Only, as I said, when you've been ordered to get rid of the pet or you've been restrained from getting that particular pet, then yeah, there was a person in Sydney that got busted for having a horse in an apartment. Yes, but generally speaking, it's actually been a really successful framework, and as the Minister said as well, it's got a lot of people through COVID, and I think it's a really significant therapeutic advantage for people too. All right, next slide. Okay, so that's just threat and intimidation existing in the different accommodations. So that's all linked so you're not disorientated by the changes in the sections. Next slide. Okay, extensions and postponements of the warrant. Okay, so let's talk a bit about this one. So there's two things that you can do to get a bit more time. One is where the tribunal is actually empowered to give extra time before the possession order is effective. And one of the new amendments is just saying they can take into account any relevant social supports or alternative accommodation. What does that actually mean? Well, what that means is that they're saying, well, it's better for someone to have the extra time and get rehoused, whether it's crisis accommodation or temporary accommodation of some form, than going directly into primary homelessness. Makes sense. You don't see this provision used very often, but it is sitting there, and that amendment is there. And that is available for damage, danger, and threat and intimidation. If we compare that to the next slide, if we can jump through them, what you'll see is that the postponement of the warrant sounds really technical. It just means that there's more time before the rental provider can go to the VCAT registry, spend $114 and get the warrant, and that gets shot off to the police. So that gives you a guaranteed 30 days where, even though you know it's all sort of over, the tenancy's been ended, you're still liable for rent, you're still in occupation, you effectively live there for another month. It's up to 30 days at the decision of the tribunal member. And then after that time, the police can execute the warrant once it's been received by them. So that's just essentially getting them more time. You can't ask for that on damage, danger, threat and intimidation notices and condition of the premises. That's where the landlord's applied and the property's been found to be unfit for habitation. So that's just a simple thing, but that applies to all accommodation types. You used to be able to do this mostly for tenancies. Now you can do it for rooming houses. You can do it for caravan parks, Part 4A sites and that sort of stuff. So that's certainly helpful. All right, next slide, please. Okay. So what the postponement of the warrant does is set out there. I won't go through this in detail just for the purposes of time, but it's important that you understand that process again with the context of review. To show or get a postponement of the warrant, it's just, hey, give me extra time. You do need to show your hardship is greater than that of the landlord. So the decision of Belias you see there is really useful. It just talks about going, if it's money versus homelessness, homelessness will trump. We're largely talking about 30 days. Again, we'll probably see similar challenges in the context of the reasonable and proportionate test, but will it be an entire defence? We'll have to see what threshold of suffering is probably the word for it to justify orders being refused in certain circumstances. Okay, next slide, please. Okay, so this is just the framework, so you have a bit of a sense of what happens when. So you've got your VCAT hearing, and then you've got the renter, what happens after the actual possession order's been made. Because a lot of people have that question of going, what happens, do I walk out of there, I'm immediately homeless? No, you're not immediately homeless. There's usually a fair few days afterwards. The only exception to that is a thing called a notice to leave. If you hear of notice to leave, call for advice straight away. They're an entirely different framework. They're quite rare. They're only in managed premises, so largely rooming houses and caravan parks. Okay, next one. Okay, the 5-strike rule. Sam will probably cover this in a lot more detail than I will, so just jump in there. The main summary is actually not a lot has changed. The 5 strikes, the legislation doesn't use the word strike at all. Essentially, it says that if you pay off the rent arrears before the termination date, it goes away. That's for the first 4 notices to vacate. So a strike is essentially a notice to vacate within a given 12-month period. So yeah, there's plenty of challenges in that space, but I'll let Sam address that just for the purposes of time. Okay, yep, jump through. Okay, so these are just diagrams again. We'll go through that. Yep, cool. And again, Okay, so what can you do to help? Sam will run through it. Largely, it's the work that you guys are already doing that we're really, really appreciative for. It's the housing establishment funds, whatever we can do to give financial support. And that's something that community legal service actually really need your knowledge about to help out to maximise that. The tribunal can now also direct people for financial counselling for the first 4 notices to vacate. So certainly helpful. But the important take home is that on any single notice to vacate, the tribunal can either give a payment plan or actually give the possession order. So that's the biggest thing, that if you walk in there with 20 grand of debt, you're not going to necessarily get to strike 5 before you face that eviction. So don't think it's 5 strikes and 5 chances. It doesn't work that way. Okay, cool. All right, rental rebates defined in the Act. So this is a really new thing, important for social housing, and that essentially is a carve-out for rent arrears. So that means that the rental rebate framework sits within the rental framework, and it essentially gives a definition, and we've never seen that before. Whether that allows any new challenges about or interacting with the rebate scheme, it still is a rebate assessed by the Director of Housing and Community Housing Providers. That's now incorporated and recognised within that legislation, and that's a pretty big shift. So we'll see what that means. Yep, jump through. Okay, reduced notice of intention to vacate as a defence. So just jump on the next one. What this essentially means is that previously people who were in, like, say, for example, you're given an offer of community housing or director of housing, you'd have to go and ask for a thing called a reduction of fixed term tenancy. That's now changed. You can actually give a 14-day notice, provide the evidence. You can see that on some of those grounds for giving a 14-day notice, and you're not going to be liable for lease breaks. So that's a really simple change, significant change, and a great defence. And it also, one of the other changes is that when the landlord wants to sell the property, if they give this new form called a notice of intention to sell, someone can actually get out of the lease by giving a 14-day notice, and that's assuming they haven't disclosed at the beginning of the tenancy that the property is going to be sold. So again, really, really useful framework there. Yep, just jump on. And it only applies to certain provisions. So they're the ones where you've got sort of reduced liability for a notice to vacate. You might get a notice to vacate, and you can give you 14 days, again, regardless of the fixed term. Yep. Just jump through. So there's probably a large number of slides that we're not able to get through today. Apologies for the clicker. I'm not sure what happened there. But certainly this will act as a resource for a lot of people, and hopefully it will give you a flavour. The minimum standards are in there. They're linked, so you know where to find them. I'll just leave probably with a comment on the minimum standards. The biggest challenge we see with the minimum standards is that they're not going to apply automatically. They will apply to new tenancies. There may be an argument to suggest that they could be included. So mould, pests, and a number of other issues are included in the new definition of urgent repairs, and air conditioning as well, subsidence in caravan parks. So a whole range of things are now urgent repairs and recognised, which is great. There's also the Part 4A and caravan park sites now have repair issues that can be addressed as well. But largely speaking, for the minimum standards, it's when you sign a new lease. So that's a little bit challenging. Then there are some particular things like the window dressings will come in next year, and then the electrical safety compliance in terms of safety switches, that has 2 years to phase in. But the safety activity, which is about getting 2-year checks every 2 years to make sure everything's safe, and that applies to all facilities and services that are electrical or gas, that's every 2 years, and a renter can actually say, can you show me that certificate and the like. So that's certainly very helpful. All right, just jump on to the next one. Apologies for the shortness of time and the lack of clicking. So duties update, yep, just jump on there. Not much has changed for the tenant. The main thing that's changed for the tenant in terms of the duty is not to interfere. So there's now this whole framework around safety activities and safety devices, and that's defined in the regulations. Things like fire doors, smoke alarms, those type of issues. So just don't interfere with them. We know people, sometimes play with a smoke alarm to try and have a cigarette or whatever in the house. Really dangerous thing for your tenancy. Obviously a safety issue as well. Yep, just jump on to the next one. And then you'll also see here that there's new safety-related activities under 65A, 65B, and the minimum standards set in that 65A, but you won't actually see them in the legislation. They all sit in Schedule 4 of the regulations. The other shift slightly is that you've got quiet enjoyment. That's been dropped down to 7 days, so it's a shorter breach of duty notice time, and the nuisance has also been reduced to a 7-day time frame. But other than that, that's not too much has changed there. The other one is the energy efficiency of clients. Whenever they're replacing an appliance, it used to just be water water, now it's gas, electricity, or any sort of appliance. If it doesn't meet the minimum in energy efficiency, the rental provider can actually become liable for that utility. So that's certainly something to watch out for. Energy efficiency is actually really difficult to measure, and certainly with secondhand items, I'm not sure how we're going to operate in that space. So certainly many questions on that I have myself. Yeah. Okay, safety activities, we'll just cover this briefly. So just be clear that that only applies to tenancy. The rooming house minimum standards sort of sit themselves just as they're there. So the 2-year electrical check. So you've got to get a gas and electrical check every 2 years, and that's, again, will apply when people renew leases. So there's going to be some of these transitional things about when that operates. So that's based on some reading between those sections you'll see down the bottom. Yeah, some places are great, but still you can have a place with no safety switch in if it was built pre-1991. So certainly well worth being aware and going and checking the box. So you get someone moving a new house, go and have a look at the box. Yeah. Okay. Jump on minimum standards. All right, this is just a table. That's where you'll find them. So the links are there. Yep, just jump on the next one. That's the actual section. So you'll see there. The other thing with the minimum standards, if they don't meet the minimum standards, there's 2 things that they can do. The first thing that someone can do is if they haven't moved in, like put their stuff in and started sleeping there, maybe you can put your stuff in there, but if you start sleeping there, it's usually off the table. You can actually terminate your agreement if they don't meet the minimum standards. So this is for new agreements post 29th of March. If you've moved in and they don't meet the minimum standards, you can treat it as an urgent repair. So the repair frameworks are largely the same. The biggest change about the repair frameworks, particularly for the non-urgent repair framework, is that you don't have to get a consumer affairs report. So that shortens. You can get one still if you want one, but you don't have to get one. So that'll speed the process up. And with the urgent repairs, you can actually get up to $2,500 worth of work done, GST inclusive, and then get reimbursed with that. And they should reimburse you within 7 days. If they don't, you can go to VCAT and get the order effectively to do that. So yeah, there's certainly a few changes just to try and speed up those processes. Yep, just jump to the next slide. And again, all right, so these are what the actual minimum standards are. I won't go through them in detail. I think the Minister's actually covered them reasonably well. The main thing just to observe in careful reading is that the kitchen facilities, it talks about if there's an oven, it's got to be in good repair, but it seems pretty clear that it actually doesn't require an oven to be provided. Similarly, with the laundry facilities, it says any laundering facilities present must be reasonable supply of hot and cold water. So you'll see that for bathroom, kitchen and laundry. There's this idea of reasonable supply of hot and cold water. What is that? We'll have to see what the case law tells us. Yep, just jump on the next one. And John, let me know if we're done on time. But otherwise, yeah, so there's that. Yeah, we are. Okay, sure, no worries. So yeah, there's mold, dampness. So mold-free will be a bit of a threshold of challenge. We've got electrical safety sitting in there. So have a look at what they look like. There's a ban on what are called RCPOs. They look very similar. You probably won't be able to tell, but just worth being aware of that from Energy Safe Victoria. Minimum lighting, ventilation actually made it in. With that big standard that looks all fancy there, it really has a very similar language to some of the other standards, which talks about it being reasonably fit for sort of the room and its function and its purpose. So, and then finally with the heaters are done in 2 stages. If there's a heater already in the lounge, it doesn't have to be energy efficient, or lounge main living area. If there's no heater at all, they are required to get a heater once a minimum standard applies, and it needs to meet the 2-star energy efficiency rating. It's not actually a very high efficiency rating, to be honest, but at least it's there and it's a great start. And then stage 2 is that when it comes to 29 March 2023, you need to have all of the premises will all have to have an energy efficiency heater. So there's a number of questions that come up in the minimum standards, like what if I rent a bungalow out the back? What are shared facilities and how does all that operate? So I'll leave that there. Apologies for the clicker, but hopefully that's a good start for everyone.
Thank you, Ben. That was a phenomenal start, if I can say, in terms of looking at what are incredibly complex changes. And I'm loving the memes and other things that you had along the way, and a bit of storytelling. I'm still picturing the horse in the apartment, but never mind. But thank you. That was brilliant.
Nice.
I'd also like to introduce Catherine Bannon. I can't see Catherine on my screen at the moment. I hope she's about. There we go. Beautiful. Thank you, Catherine. Catherine's the Executive Director for Regulatory Assurance and Policy at the Department of Justice and Community Safety. I would also like to acknowledge that these VCOS Renters Rundown events, they're made possible by the support of the department, and this has very much been a partnership. We look forward to continuing our partnership with the department, and Catherine, you've been instrumental to that, so I'd like to acknowledge that from the outset. Catherine's team leads the implementation of these changes. So I'm really excited about this panel. I think it'll be fantastic in terms of looking at the combined knowledge of Catherine, Ben, and the questions that we're going to have, and looking at how we can toss some questions and things around as well. So Catherine, thanks for joining us. Ben, thanks for a brilliant presentation that covered an awful lot incredibly quickly. There's going to be lots more to dig at, and I might just jump straight to the questions if that's okay. The first one I've got is for Ben, and Catherine, feel free to jump in. If or either of you have sort of directed the question at one of you and there's anything that you want to add, obviously jump in. So for Ben, do tenants have to pay upfront for urgent repairs and then get reimbursed by the landlord? Most clients don't have the money to pay upfront for issues such as mould.
Talkie, no, Mike, classic. So generally we don't, we don't expect people, and I personally don't think it's a good idea that people spend that money and then have to chase after that money. There are actually some changes in the VCAT Act under Section 120A that allows you to go, hey, I got a monetary order saying that they should pay me and they haven't paid me. Can I go back and get that offset against my rent? It's a better option, yeah, but if people are moving out, it can make it more complicated. Ledgers get messy. The simplest thing that we tell most people is, tell them about it, get your evidence. That might be a photo, whatever, document it. Apply under Section 73. VCAT has to list that hearing within 2 business days, and most hearings are done on the phone now, which I think a lot of tenants actually quite like. It's a bit harder to present your evidence, but you can send that through. And once they're satisfied of that, you get your orders, and then you've got enforcement, the compensation's clearly running. So while the framework of reimbursement for people that might have that money available is good, and it might get it done more quickly if you've got a really resistant landlord, I generally think it's just much better to get that into VCAT. It's better accountability. It creates a record. It's factually found, that the landlord's responsible. And a lot of people can also amend their applications to ask for compensation as well. They can say, well, look, I'm out of pocket. These are my expenses. Can I renew and come back, in a month and deal with the compensation side of this? And a lot of people in that window of a month might actually resolve it by agreement as well. So it's heartbreaking to see people. We saw one the other day where, the roof, had water just pouring in, and, been living that for 9 months. It always breaks my heart, and I understand that people are scared. There are real consequences. Who wants to be homeless in this time? But the framework of removing that no reason notice to vacate just makes it that much better for people to be more confident in taking those steps without fearing that their family or themselves are going to be displaced into homelessness.
Thanks, Ben. Much appreciated. Catherine, my next question is to you, and it's around what legal or financial obligations do real estate agents have where a landlord doesn't want to meet their obligations or they don't follow the law?
So I think it's important to note under the RTA, but also under the Estate Agents Act and the associated regulations, there's a number of obligations for real estate agents to act honestly, fairly, in compliance with the legislation as well. So where there are examples of renters who are providing a request for people to either fix, to action a repair, to comply with an obligation under the RTA as well. If that's not occurring, while people can pursue that through the framework as well for taking action for breach notices and things like that as well, there is also the obligation with non-compliance that can be reported through to Consumer Affairs Victoria. As I said, there are obligations and offence provisions for real estate agents and property managers particularly where they are not following the requirements to act in compliance with the expectations which are set out in legislation. So that pathway as well is something which people can do in conjunction with enforcing their own rights as well. And that does have monetary penalties as well as a whole range of other compliance options which are open to the Director of Consumer Affairs to consider, and that can include taking disciplinary actions against estate agents who are doing the wrong thing, seeking injunctions, taking criminal proceedings if necessary, depending obviously on the severity of the non-compliance which can be identified. I would say to support sort of those type of actions, it does require people being willing to give evidence as well, and to assist the Consumer Affairs as the regulator in taking those actions. But there is a framework built in that does allow the Director of Consumer Affairs to take action where necessary for anyone in the property management area who is not meeting the expectations which are set under the Act.
Thanks, Catherine. So Ben, my next question is directed to you. In terms of property modifications, so it states that landlords can't unreasonably refuse consent. Is there a stated definition of what unreasonable looks like?
If the word reasonable was defined in the law very specifically, I think every lawyer would celebrate and cheer. That's really sort of where the role of a jury, or in this case, you don't have a jury, so you've just got a member saying, well, what's reasonable? And you can argue that out, but unfortunately, it's not that clear. Apologies for not getting for the mods. They are in the slides. Just to give you a bit of an overview of the modification changes, the old framework used to be pretty much if the landlord says no, unless it's an equal opportunity modification under 55 of the Equal Opportunity Act, that's sort of the end of it. Whereas now we have a really brilliant framework. It's got two classes of modifications. It's got modifications where you don't need consent at all, and then you've got modifications where consent cannot be unreasonably withheld. One of the major flags within the modification framework is around CCTV footage, so particularly thinking around family violence, is that if you've got a standalone system that's not hardwired and pointing right into your neighbour's place, you can get that and you can install it. The main thing that they're a bit cagey about in the legislation is sort of penetrating concrete or brick walls, because obviously that's sort of some structural stuff and people might do something a little bit heinous. There are grounds set out, so this is section 64 we're talking about, and again it's just tenancies, it doesn't apply to rooming houses and caravan parks and the like, where they consider it would be reasonable for the landlord to or the rental provider to refuse consent based on these factors, but at the end of the day it's up to the tribunal. And I think that there's certainly grounds, so things like thermal comfort are some of the reasons that renters might want to get their energy efficiency, because we're seeing utility bills, particularly if people are working from home, shot up. So that framework is really important, and I guess the best thing about it is going, if people can't reach an agreement, it actually ends up into VCAT I think within 5 days, so it's a really quick process to allow people to come to it. They can ask for an extra bond if they think that the work's going to be more than $500. It's really about facilitating people being sensible and reaching an agreement. The main thing with modifications to be careful of is just because you've got the consent to do it doesn't mean you're not going to be responsible. Like if you poke a hole in the wall and you put a hole in the wall, you need to fix that. Does that raise painting issues? So just be careful. This is talking about consent. Unless you have a written agreement saying you don't have to restore it back the way it was, you could still have a bit of a financial dispute over what does restoration costs look like. So great framework, but people just need to be not overzealous in how they approach this and stick 39 holes in the wall. Yeah.
Thank you. The next question is both to Catherine and to Ben, actually. So we've got a question coming through saying it'd be great if someone could elaborate on how this might affect the Office of Housing Properties or transitional housing models. So I'm not sure who to throw to first. Maybe Catherine, if I go to you first and then to Ben.
Yeah, absolutely. Look, broadly with the RTA, obviously there are frameworks in place for all type of tenancy arrangements, including those which are offered by social housing providers as well. So there are specific requirements based on the type of tenancy. I'm not sure, Emma, was this in relation to modifications particularly, or was it more broadly in relation to the entire sort of new RTA, the question?
The question's not specific, actually, so I suspect you could probably interpret it either way.
Okay. So there are... Yeah. I suppose I would say yes. So the framework broadly does apply to public housing properties as well. And in relation to the framework for modifications as well, that I would encourage people to check the relevant parts of the Act, which I can definitely bring up as I'm talking to you to refer to it, but Ben may know it off the top of his head because I'm exceedingly impressed by the level of detail that he has on this that I don't.
Schedule 3, Schedule 3, the regulation.
That's just, yeah. But if it's in relation to things like notices to vacate and when the standards come in and those sorts of things, again, they still do apply to those properties, and there is specific requirements for Office of Housing properties as well.
Thanks, Catherine. Ben, I might throw to you for anything to add and for Schedule 3.
Sure. Look, so with the mods, I mean, the Director of Housing's always been pretty good with mods. Mods become really controversial because, you know, you're like, oh, I want to put a bar in the bathroom, and you go, oh yeah, that shouldn't be that hard. And then you get a bill saying, tradie saying, that costs $12,000. And you're like, $12,000? It's a screw-through tiles and a studs. Oh my goodness. So you obviously want everything to meet the AS standard and you want it to be safe. But the costs are usually what sort of, I think, cause the disputes about how do you manage this. Because when we're talking in a private tenancy, modifications are things where, yes, you can get the consent again to do it because it's necessary, but a question of who pays for it. And since the NDIS got introduced, there's this question of going, well, the Director of Housing actually, and you know, through the Department of Human Services, used to pay for quite a lot of things, which I think was appropriate and necessary and very much appreciated. With the NDIS, we've seen a shift of that cost from being state to federal and a bit of tension around, well, who pays for what in relation to these modifications, and then also restoring it. So there's a broader policy issue about when we're building particularly new stock, it meets a certain standard, which includes a population and community that has disabilities and special modification needs. So the framework and the legislation will allow that to be unpacked, I think, a lot better than it previously has, or at least a lot more people will be aware of their rights. In relation to the minimum standards, as I said, it's difficult and frustrating to think that, you know, on the 29th of March, it's not going to apply to everyone straight away. These things do have to be phased in. There's costs and there's transition, there's monitoring and those sort of things. So I guess what in some ways we'll be looking to have conversations with what is now DFFH is to work out, well, what does this look like for people in long-term tenancies? You know, what does the minimum standards mean? I mean, a lot of them will already be being met, but it is important just for people to be aware. And one of the strange things about the minimum standards, which I think will end up at VCAT, whether successful or not, is that an urgent repair can still include something not meeting the minimum standards. And Section 65A says, without limiting, you know, what the duty of good repair looks like, you know, this is, you know, the property should be in good repair. So we'll see what that looks like at VCAT. But certainly for the new rentals, we're looking forward to having that benchmark for all people having a safe and secure home that they, you know, is on par with any other consumer product. You know, you wouldn't sell a toy that you could get electrocuted with, so we expect that houses meet that same standard.
Yeah, absolutely. Thank you. My next question is to Ben, and that's around, has there been any change to minimum standards or urgent approval of security measures or property modifications due to family violence? Even if it says here, even if funded under family violence funding.
Yeah, sure. Look, with the family violence, yeah, that really sits within that modification framework. It's really about consent. So there's 2 tiers of consent, which you'll see in that Schedule 3 about the modifications. And the modifications really address the CCTV footage that's installed that's not hardwired. So that means connected to the, you know, 240 volts of the house. And then there's another one that actually is hardwired into the system. So there's certainly different systems and they're much more accessible. There was a lot of discussion about whether or not it should be mandated that it has to be installed by a qualified person. So with the duty for good repairs, that all now needs to be done by a qualified person. So gas and electricity, there are standards that says, look, no one else should be doing that except, you know, a sparky or a plumber. That will be the source of a subject law of saying, well, does it have to meet the AS standard, the Australian standard, when a repair is done? For the family violence context, it certainly is well worth, you know, whoever the family violence support worker is, working out, is this just a simple system that we should do? Or if they're part of the RAMP program, for example, where there's just such a high risk of violence that you really want that installed in such a way that, you know, it's not going to be blocked out easily without seeing the person, because that evidence is always essential for the prosecution. It's not criminal to have an IVO against you, an intervention order against you, but it is criminal for someone to breach it. And that's really what you're doing, is you're equipping someone and empowering someone to have the evidence they need to make sure that order is meaningful and enforced. And that's really difficult. So if you have got someone on their own trying to sort of stick up a system and it falls down, or it doesn't have recording, or it's not maintained, you're going to lose that evidence. So as far as those modifications, security on locks and doors, absolutely. There's funding out there. There's VOCAT, which is Victims of Crime Assistance Tribunal. Violence is a crime. Let's treat it as such. So yeah, it's about making sure that those measures, which previously a landlord could go, no, not going to do it, don't want to do it, don't want a security door, that's changed. That's a big game changer, and hopefully will really enhance safety plans for people that have experienced or experiencing family violence.
Fantastic, thank you. Next question to Catherine. So can a landlord increase rent to cover the costs of safety checks, or is that considered unreasonable?
So under the framework, there's only the ability for landlords to increase rent once a year, and they have to explain on what basis that they're doing that. So there's a framework that they need to do that with reference to the market value or a data source that they're accessing. So it wouldn't be permissible to say we're raising rent because we have to cover mandatory gas or electric safety checks.
Fantastic, thank you. For Ben, so can a renter who doesn't have a lease agreement, so for example, international students, I'm thinking about the dreadful time they've had, particularly during COVID, so people who are house sharing who lease a room only, can they seek assistance under the new laws?
Yeah. So the first thing that anyone will ask or a lawyer will think of is going, what laws apply here? It's referred to as jurisdiction. So when someone's renting a room, we have to ask that question, do they have what's called exclusive possession? That's a whole doctrine of law, any arguments. The Residential Tenancy Act is presumed to apply. So that's kind of the starting point. The tribunal goes, well, I think this does apply unless, someone can show to the contrary, or if I really think there's just not the indicators of a tenancy. Main indicators are you pay rent, you've got exclusive possession, meaning you can exclude other people out of a particular area, so it doesn't have to be the whole house. You can actually just rent a room. We saw that in Supreme Court decisions called Janissauskas a number of years ago. So I think that for an international student, the take-home would be seek advice, because everyone's situation is going to be different. You might have share households where everyone's rent and there's someone that's not on the lease. They probably are a licensee. But if you say, for example, live with an owner and you rent a room, you might have your own entrance into that room or a lock on your door, not that that's a conclusive indicator. And they actually might be covered by the Part 2, the tenancy part of the law. And that's why the minimum standards go, oh, what does that mean? Do I get my own heater in my own room? We'll have to see what that looks like under the new legislation. So I think for international students, once the Residential Tenancy Act applies, the biggest benefit is that to get them out of that property, they have to go through this notice to vacate possession order process. So that's really the biggest protection. That brings liabilities and responsibilities as well with them. But I think the biggest thing for international students that are in those unusual situations is to seek advice. The other thing that we see quite a lot with international students is rooming houses. So a rooming house is where you've got more than one room where it can be rented out by more than 4 people. So someone sets up a house and they're renting out all the rooms. They may or may not live in that house as well. And they've sort of each got their separate agreement. So once you reach that threshold, you actually have Part 3 of the Act, which is rooming house provisions apply. And certainly Catherine and myself are very interested in hearing about that, because we know in those sort of environments where people think they're doing something wrong, but it's their home, that, there's a lot of fear, and we really want to provide clarity about what the law is, and they've done nothing wrong by living in those environments. So the other thing, just briefly, of what Catherine was saying is with the reporting of things, like particularly community workers probably hear a lot more than we do. Hey, how come this particular provider keeps on popping up? That sort of intelligence of a repeat issue or offender or someone that doesn't do things the right way, we really want to hear about them, because you'll probably see them. You're dealing with those cohorts of international students, and we see people that run 8 rooming houses and are profiting massively. So certainly very, very interested in making sure that everyone is protected with the rights that they deserve.
Emma, can I just jump in to echo that?
Yeah, of course, jump in.
Yeah.
I think equally, as I'd said earlier, sort of for the more detailed enforcement action, it does take having people willing to sort of go on record, so to speak, but that shouldn't be for this group particularly, even if the intelligence, if you don't have people, residents or clients that you're working with who are prepared to go on record as such. If you do hear about rooming house operators that are of concern, rooming house operators do need to be registered in the state. That was introduced a few years ago as well. So that is a public register that can be accessed to check that they are registered. But if there are things that you're hearing about people being exploited and whether you're sure, I'm not sure if it fits under a particular offence or not, but something's just not fitting right with this an operator that you're hearing about. Consumer Affairs is interested in hearing it, and it will definitely be able to be fed into the intelligence and risk assessment that they do in their compliance monitoring across the sector. So whether that's
Sure, thank you. Sorry.
managers, houses as well. So I think that's just something I wanted to reinforce, that even just the concerns that you're hearing with your clients is something that can be fed into Consumer Affairs.
Thank you. That's a fantastic point to make as well, Catherine, and really important. This question's really for both of you. So if someone's signing a lease before, or they're sort of before the start date, so this week, for example, will a new legislation apply, or will it only be when at the point when the lease is renewed?
Do you want me to tackle that one, Catherine, or do you want to?
Well, yeah, I'm happy to defer to you. That's fine. Yes.
Sure. Look, this is a question everyone's asking. Look, generally it will for future things. So, for example, there's a whole raft of protections that you'll see in the slides I provided about what should happen at the beginning of the tenancy. So there should be a prescribed form which includes, this is information about discrimination. There can't be misleading and deceptive conduct, a whole bunch of other things. So obviously that won't apply because it's not relevant, because the law isn't in place at the moment. So there are certain things. So the minimum standards, as I said, that's a pivot where you're starting a new lease. So they're going to miss out if they sign this week as compared to sort of, midway next week. The safety related duties or the safety activities, that will apply when you get a new tenancy. It could be a renewal. That's our opinion anyway. So they'll probably miss out on the safety activities. I think a good rental provider will probably be doing them anyway, but it's not the same duty. And then for things like the duties where the renter shouldn't interfere with them, they'll apply. So the vast majority of them will actually apply. We're seeing a lot of changes around really termination, ending the tenancy, bonds as well. So for example, the bond framework has changed significantly where a renter can apply now directly to the RTBA. The RTBA then sends out a notice to everyone else on the lease, including the rental provider, to say, I've got a claim in here, unless you lodge an application to VCAT within 14 days, I'm going to give the money out as it's been requested. So that's a big change. And the rental provider's got 14 days to get into VCAT to make that application from the notification and the time the tenancy ends. So there are a large number of changes that will apply regardless of entering a new lease. But if you've got any doubts, it's probably when you need to seek advice. Yep.
Thanks. Catherine, did you want to add anything in there?
No, just and equally again, I know Tenants Victoria has a wonderful assistance program, but also Consumer Affairs has got its call centre as well. So if people have any questions either before they're signing the lease or what applies to their particular circumstances as well, I just would also let people know that service is available, and there will be information that will be going live on the website consumer.vic.gov.au as of 29 March. There's some information which will be provided to assist people in this group, as well as in relation to some training materials that can be modified and shared separately through a SharePoint document. But in relation to the information, will be up on the website as of, I think, probably midnight on the 29th of March. But there's some information to a limited degree currently available, but given that the framework hasn't kicked in yet, it's still as at the current settings for the COVID settings at the moment.
Thank you. I've got a couple of questions that I'm keen to get through if we possibly can. So let's give it a shot. So the next one is for Ben, noting that Sam's going to cover changes around family violence in the next session as well. But quick question around for victim survivors of family violence, when safety measures are required to the rental property, is there a time frame for the landlord to give authorisation?
Not really. So it goes within the same modification framework under Section 64. So the hearings are mandated to be listed relatively quickly, being 5 days. Whether anyone wants to go ahead and do them without consent, we generally wouldn't recommend that. That's probably something to discuss with the registry of VCAT if you need to get something even fast-tracked even quicker. But obviously safety is paramount. So I think if the grounds are there, whether the tribunal can give retrospective sanction of something it's already done, it's really just about making sure that that everyone is safe. I'd be surprised if there are landlords that are so resistant, where there's family violence in place to refuse consent, particularly where the framework is now pretty clear, and I think the outcome is going to be pretty obvious of what will happen in that situation. So the first thing is to try and hope for the best in terms of goodwill from the landlord, that we're all in this as a community, that it's all our responsibilities to stop family violence or any sort of violence against people.
And Emma, can I
Thank
just
you.
say
Anything you wanted to add? Yeah, thanks.
Just to flag, I think it is worth, if people are comfortable in flagging it directly with the VCAT registry, I know they are committed as well to prioritising family violence matters. So whilst there is the set time frame, wherever possible, I'm very aware that they bring forward family violence matters as quickly as possible.
Yeah. Thank you, Catherine. And that's very important for people to be aware of as well. In terms of, I think this is probably one for you, Catherine. I'm not sure whether, in fairness, I'm not sure whether you can answer it, so I'll flag that up front. There's obviously concerns about renters who are going to face financial hardship when the emergency measures end, and I know this is something that we have all been raising. Are you aware of any plans around extending the rent relief grant or other measures that could be introduced?
So definitely is something which I know, Emma, we've discussed, and with Tenants Victoria it's been discussed, and a number of probably representatives from this group have raised it with the department and with our colleagues at DFFH and ministers' offices as well. So it's definitely something which is on the radars, and we're also very much aware of the potential risk. It has been difficult in trying to quantify what it will look like for people, the impact of the cessation of the Commonwealth measures come the end of March, and what that means for people who have a vulnerable tenancy. So we are very interested in hearing case studies about where people actually do have notifications of these issues arising. So all I can say, it's something government is considering and is aware of, and has been very well advocated for by a number of groups who are here and represented today. And it's something which we're working through at the moment.
Thanks, Catherine. In terms of a slightly related question as well, can a landlord increase rents to make up for a reduction that was applied during COVID, so to sort of make up losses from last year? It's probably one for both of you, but I might start with you, Catherine, and then shift across.
Yeah. So yes, they're entitled to increase rents once a year. So that's the new framework. And as I said, there are two standards that they have to refer to. So an increase to make up sort of $4,000, $5,000, because the basis of that is what is the outstanding debt from last year, so to speak, is not something which would be permitted. If people want to seek, it is open to renters as well to seek advice from Consumer Affairs in relation to the proposed rent increase, which then can assist them in taking the matter to VCAT to challenge it as well. So if it is simply, a clear-cut case of raising rents outside the scope of the market value in the neighbourhood, or against the I think it's the ABS data as well, then that is something which I would imagine VCAT would not look favourably on if that was to proceed with the support of a review from Consumer Affairs to VCAT by a renter.
Thank you. Was there anything else you wanted to add in there as well, Ben?
Look, so talking section 44, one of the minor changes in there, that the rent increase notice now has to describe the method upon which the increase is given. So it's a market-based test, which means that the sort of comparison, certainly in my area, I'm seeing a lot more for lease signs going up. So what that means with interest rates being particularly low, it's unfortunately not a hardship test between either the tenant's experiences as a result of the increase or the landlord's, whether they're paid off the rent. So it is a market-based test. So methods of rent increase is a bit strange because it's not defined in the legislation. You can see examples of that in Form 2, which is the long-term tenancy agreement. So things like CPI, SRI, or fixed increases as well. So certainly the method is something I think that would be stricter, and I think Catherine's absolutely right, trying to compensate yourself, for the rebate or deferred rent. The biggest issue we'll see in this space, I think, is deferred rental agreements and how they're treated, or what that means in context, because that'll present in rent arrears matters. But I'll leave Sam probably to discuss that in a bit more detail.
Thank you. And on that note, can I just say a huge thank you to you, Ben and Catherine? It's been a fantastic session. We've been able to get through lots of questions. I can see there's still a few more there. So if you've put in a question that we haven't covered, we will get back to you. But we've got through a lot, so that's been fantastic and covered an awful lot of ground actually in terms of looking at the significant changes coming and having the chance to answer questions. We're going to move into a short 5-minute break now. So we will have a quick stretch break and then be back at 11 with Ian Goff chairing the panel from CHP. So again, huge thank you to Ben and Catherine and of course to the Minister as well for this morning, and see you in 5 minutes. Thank you.
Yep, I am. Good. Hello, everyone. Thank you, Emma. My name's Ian Goff. I'm the Manager of Consumer and Capacity Building Programs at the Council to Homeless Persons. Thanks to Emma and the team at VCOS for inviting me to participate today. In case you've tuned in, welcome to the Renters' Right Rundown, Victoria's a forum on Victoria's new renting rules. It's part of a series VCOS is running to inform the community sector about issues and policy relevant to Victorian renters. Before I kick off, I'd like to acknowledge the traditional owners of the land on which we're all meeting. Pay my respects to elders past and present and emerging, and extend that respect to Aboriginal and Torres Strait Islander peoples with us. Just flagging, I can hear someone in the background talking, so I'm not sure. I'm guessing that's not supposed to be happening. The session today is supporting consumers navigating the change to the RTA, and the focus is supporting, helping support workers understand the changes to the RTA and how they might impact the people they are working with, and how they can best help their consumers that they're working with and supporting. Support workers and case managers across the community service sector will play. Can I just for the host, I'm getting noise through the speakers, which I presume others might be as well. So there's another mic on that's not muted, perhaps, or as I said, support workers and case managers across the community sector will play a critical role in informing consumers about the changes to the Residential Tenancy Act. And help them understand the potential impact of those changes, support them to navigate the new environment for renters in Victoria, understand and exercise their rights, and take advantage of the positive opportunities that the changes will bring. For this session, I'll be moderating a panel. Joining me today on the panel, and I'll let each of them introduce themselves more fulsomely when we get to them. As we get to them, Samantha Sauerwein, Head of Community Programs at Justice Connect, Damien Patterson, Policy and Advocacy Officer at Council to Homeless Persons, Helen Matthews from CHP's Peer Education Support Program to provide an important consumer perspective, and Neil Parker, Housing Options Worker at the Entry Points team at Launch Housing, who will provide a valuable support worker and case management perspective. The session will start with Sam doing a brief presentation focusing on preventing evictions. She'll be followed by Damien, who will briefly speak about supporting people to find or maintain their home and common advocacy issues. After Sam and Damien's presentations, we'll have a Q&A session with the whole panel, Sam, Damien, Helen and Neil, which I'll facilitate. And the focus of that session will be on the theme Sam and Damien have touched on and discussed. Just some quick comments on process. You can submit a question at any time through the Slido box underneath the video, under my video here. Karen from VCOS will be moderating the questions. And it's likely there's going to be a number of similar topics or questions, and she'll theme them up so we get through as many as possible. Please note the panel won't be able to answer all of the questions or about individuals or specific individual circumstances, and we'll get to as many questions as possible. But if we don't get to them, we'll certainly look to take up any unanswered questions and try to follow them up. But also, just to let you know, CHP is looking at developing training and information for the homelessness sector. So please, I really encourage you to post any questions or thoughts you might have, as I'm going to get a copy of the questions from VCOS, and that will be really important for us to inform the work that we're going to do in developing some training and capacity building activity for our sector, and give us a sense of the areas we should be focusing on. So without further ado, I will hand over to Sam.
And thank you so much, VCOS, for having us. It's really exciting in this lead up to the new rental laws to be able to to really, talk about what's important. And particularly, I think this session that Damien and I and the panel will be doing, really looking in a more focused way practically on what it means for the community sector and particularly for workers trying to support people with this new tenancy system. So my name's Sam Sauwine, as Ian mentioned, and I'm the Head of Community Programs and the Principal Lawyer at Justice Connect in the Homeless Law team. And I want to start as well by acknowledging the traditional owners of the land on which I am today, the Wurundjeri people of the Kulin Nation, and pay my respect to elders past, present and emerging. So I'll see if my slide clicker works. Oh, and I'm having issues with it too. Just give me a moment. I'm going to reload. Here we go. So I just want to give you an overview of what I'll be focused on today, and it's fantastic that Ben could give such a comprehensive overview. I really want to focus on 4 key things. The first thing is really the most important thing, I think, in relation to evictions under these new laws, which is the reasonable and proportionate test, and the role that you can play if you're a support worker or if you're in the community sector, helping someone to prepare if they are facing eviction. The second one is in relation to the new rental arrears process. So just giving you a bit of background, but once again, focusing on how you might be able to support people who are dealing with rental arrears under the new laws. Thirdly, I want to talk briefly about breaches of duty and compliance issues. That will make more sense perhaps when I get into it. There aren't so many changes to that process in the new laws, but they're really important as workers supporting people who might be at risk of eviction, because these processes come up frequently. And then finally, I think as Ben flagged, I'll just talk through some of the family violence options available under the new laws, which are a real win. And I think as a sector, we're really pleased about the options for people experiencing family violence. So I'll start now by giving you a quick overview. And once again, I'm having issues with my clicker, so I might need to get someone to scroll for me, of who we are at Justice Connect. Our homeless law team is Victoria's free community legal service for people experiencing or at risk of homelessness. We help people in a range of areas, but particularly in relation to tenancies. And all of the areas that I'm talking about today are areas that we work in. So more than happy to accept referrals in relation to any of the issues I discussed today. And we're also always using the casework we do to try and advocate for better laws and policies for people at risk or experiencing homelessness. So without further ado, the reasonable and proportionate test. Ben has already spoken somewhat about this, but it was a bit of a refresher in case you're not familiar with the process for eviction. I won't go into detail, but what you need to know is that there is a process and it doesn't end with a notice to vacate. So basically there's a stepped out process that starts with a notice to vacate and ends with a warrant of possession. I won't go into more detail because I know Ben did, but I wanted to provide that context. Where the reasonable and proportionate test fits into the eviction process is when a rental provider or a landlord applies to VCAT before they want to evict someone. So if someone doesn't leave the property when they've received a notice to vacate, the next step is for the landlord or the rental provider to apply to VCAT for what's called a possession order. And the exciting thing about these new laws is that they bring in a new test in relation to evictions, which is called the reasonable and proportionate test. And basically, you'll see there that there's a range of factors that the tribunal has to consider before they can evict someone. And they need to look at the impact taking into account a range of parties. So that includes the renter themselves, it includes the residential provider or the landlord, but it also includes any co-tenants or any neighbours. So it's quite broad in terms of the people that are considered, but also you see as we go through the criteria that the tribunal can consider in terms of deciding what's reasonable and proportionate. So the first thing is really looking at conduct of the renter. So that includes the nature, frequency and duration of the conduct that's been alleged. So that's often the case if there's conduct issues. So if it might be that someone's, alleged to have caused serious damage or there's danger. So they'll really look at that in relation to it. They'll also look at whether the breach is trivial. So they have to look at how serious the behaviour or the conduct is that's alleged. They also will look at whether the breach was caused by the conduct of any person other than the renter. Now, that's really important if someone's experiencing family violence, for example. So if there's a perpetrator that is the one that's actually causing the issues or has caused the damage, that's going to be relevant to whether it's reasonable or proportionate to evict the person. You'll see as well that it's explicitly named here that if there's an intervention order, for instance, that's something that the tribunal will consider. So once again, family violence is really important here in terms of understanding what's going to be reasonable and proportionate in the circumstances. Other factors, so it continues, there's quite a few, is whether the breach has been remedied as far as is practicable. So that's really important when you're supporting someone. It might be that there were issues around, damage that's been done to the property, but that damage has actually now been repaired. So that's going to be really important to provide evidence about that. They also look at whether the renter has or will soon have capacity to remedy the breach. That's important because they don't necessarily have to have remedied the breach already, but they have to have the capacity in future. And that's where there can be really good evidence about someone's capacity, for instance, to get mental health support, which will mean that they're not likely to engage in that conduct in future. The tribunal will also look at the effect of the conduct on others. So that's really neighbours, co-tenants, etc. And this is a really important one, whether any other order or course of action is reasonably available instead of making the possession order. So this is really important in terms of the ability to consider other options rather than evicting someone. And where there's behavioural issues, there's actually explicitly the ability for the tribunal to make what's called a compliance order rather than evict someone. And a compliance order is basically saying to someone that you must not engage in this behaviour or you must do X, Y, Z, and if you don't, you might be evicted. So it's really important that that option is available, which is an alternative to eviction. They can also look at any other matter that the tribunal considers relevant. So really broad in terms of what the tribunal can look at, and that's good news because if we want to avoid eviction, there's a lot of ways that we can put forward evidence to show why it's not reasonable and proportionate in the circumstances. Just quickly, I know that when we're lawyers talking about the law, it can be pretty hard to make it feel practical. I thought I'd just give a quick case study, which is Miko versus Burgess, of how the reasonable and proportionate test was applied. This was one where a landlord wanted to evict the tenants so that he could move into the property. And the question was whether that was reasonable and proportionate. And VCAT decided that it wasn't, even though the landlord had sold his property already, basically looking at the tenant's circumstances. So the fact that the renter had children in a school nearby, was immunocompromised, and had financial issues, meant that it would be disproportionate to evict them, and that the landlord had other options in terms of moving into other properties. So it's really important, I guess, realising that this, in practical terms, can really stop people being evicted by really weighing up what's reasonable and proportionate, looking at the landlord's circumstances and the renters. So what does this mean if you're a caseworker? And apologies, I'm having a sticky internet clicker when I'm trying to move my slides. So what does that mean for you if you're trying to support someone at VCAT? Basically, it's all about the evidence that we can bring to VCAT to show that it wouldn't be reasonable and proportionate for someone to be evicted. So that might include evidence to show the steps that a person has taken to remedy the breach or how they might be able to remedy the breach. So that might be about the support that they've engaged with, that might be about repairs that they've made, a whole range of things. The other thing is letters from medical professionals or from support workers to explain basically how an eviction would impact on someone's health, physical or mental. So that can be really important as a consideration. The other thing that's useful is if you've got things like evidence that someone else caused the issues. So that's if there's a perpetrator of family violence, that could be an intervention order. That would be really important. And then basically evidence of any other reason it's important for someone to remain housed in their current housing. So that could include special supports they have, access to specialist services, cultural links to the area, or even modifications that have been made to the home for them. So all of that evidence is going to be really important to be able to provide to the tribunal to show that it's not reasonable and proportionate to evict. I just quickly wanted to touch on, before I move on to the next topic, VCAT hearings themselves and what you might be able to do in relation to adjournments. So if your client has a hearing as a support worker, you can actually ask for an adjournment, but VCAT doesn't like to adjourn except in in circumstances where there's good cause. So you generally have to give notice, ideally 2 business days prior to the hearing at least, and with consent from the landlord or rental provider. But you can also ask at the hearing itself for an adjournment. The thing I would say to be really careful about, and Ben spoke about this, is that if your client doesn't attend a VCAT hearing, they do have the right to request what's called a review, so a new hearing where they can attend. Be careful if you're supporting someone with a VCAT hearing, if you attend on the day, even if the tenant or renter doesn't, then they won't have the right to ask for a review. So it's really important that you don't necessarily appear without a client, because then they won't be able to have review rights. So I'll just move on now, just aware of time. So the next thing I wanted to talk through was the rental arrears process. So the rental arrears process, Ben spoke about this in brief, and basically it's a new arrears process, but it won't have necessarily a significant difference in its application on the ground when you're working with clients. So basically, if someone is in rental arrears, as they did previously, they can get what's called a notice to vacate if they're 14 days or more in arrears. Importantly, as Ben stated, you don't need to leave just because you've got a notice to vacate. The important thing about this new process, though, is that depending on how many notices to vacate you have received within a 12-month period, then it basically changes the options available. So if the notice to vacate is a first, second, third, or fourth notice to vacate in a 12-month period, then basically the renter has more options. If the renter pays back the arrears by the termination date on the notice, then basically the notice has no effect and VCAT cannot make a possession order if an application is made for one. So it's really important to know how many notices someone has, because it will determine whether or not they can access those kinds of options. If the renter can't pay the arrears by the termination date, which is often the case for our clients, certainly they're not often in a position to repay all the arrears in one go, then the landlord, the rental provider, can apply for what's called a possession order. Now, this is important because if it's the first, second, third, or fourth notice to vacate, VCAT has the option to refer a renter for financial counselling and also to make a payment plan. So that's often what will be the best option for people, and enables them to pay the arrears off in a way that's manageable for them. However, if it's the fifth notice to vacate within a 12-month period, the options at VCAT are really limited. So there's no option for financial counselling or payment plans. The only protection that will be available if there's a fifth notice will be the reasonable and proportionate test. So it's really important, if a person is unsure of how many notices to vacate they've received within the 12-month period, or you're not sure, that then you get some advice and help from a lawyer, because we can then help determine what their options will be depending on the number of notices. The other important thing that's confusing, and I think we'll all be wrapping our heads around, is what the 12-month period is. The 12-month period starts from the first day of the tenancy agreement. So it will reset every year from the anniversary of that rental agreement. So what does this mean if you're actually trying to help someone with rental arrears? Basically, one of the things that's the most effective if you're supporting someone with rent arrears is thinking about offering a payment plan to a landlord or residential provider. So working out how much is owed, what's sustainable for someone to pay off over a period of time, and then putting that proposal to a rental provider. Often they will accept that, and it may stop them from applying to VCAT for possession. One of the things I wanted to promote is a tool that we've developed at Justice Connect called Dear Landlord. And it's a self-help tool that a worker can use, but a client can also use to help generate a tailored letter to a residential provider to offer a payment plan. And we find that in a lot of rental arrears cases, this can mean that a payment plan is made and that the landlord rental provider doesn't apply to VCAT for a possession order. Note, however, that if it is a fifth notice to vacate, like I mentioned, there really is a high risk of eviction. So if you're not sure, you think it might be a fifth or it's getting close to that, please don't hesitate to get some legal help. The other big thing that Ben, I think, indicated was the role of financial assistance. So I'm sure a lot of people here would be very familiar with the financial assistance available, and that is hugely helpful where there's brokerage. So whether it's through the PRAP program, whether through HEF or other brokerage programs, trying to access financial support for people so that when they're offering a payment plan, whether they're doing it directly to a landlord or if they're doing it at VCAT, that you've got a sense of what upfront payment there might be able to be made, and then what supports are available to help pay off those arrears. And the other thing, obviously VCAT can refer to a financial counsellor as well, but if you're seeing someone struggling, then it's really recommended to consider whether a financial counsellor might be able to help, because they can draw together the bigger picture around not just rent that's owed, but also other debts and other issues financially to make sure that they can help someone pay off arrears, but make sure they're financially sustainable as well. I've just put a slide up, but I'm just not going to go through it at this point, that has some key legal and financial resources. I know VCOS will be circulating these slides, so you'll be able to look at those once we circulate those and give you more detail. Apologies, this internet clicker is really not working for me. So I'm now going to move into the third part of the presentation, which you'll remember is about breach of duties and compliance. I'll do this relatively quickly, which is just to say that there are a number of duties for both renters and for rental providers within the RTA. And this is important because what we see is a lot of people who are alleged to have breached some of these duties, and that can give rise to a range of processes that I'll talk through. The most common ones are around nuisance, so a tenant must not cause nuisance or interference with the reasonable peace, comfort or privacy, and those are often ones that we find our clients breach and are most relevant. So the process for seeking compliance is this, and I just thought it'd be good to outline it. The reason it's important to talk about breaches and compliance is because they can lead to eviction. So what the process generally is that if someone's alleged to have breached one of those duties, they will receive a breach of duty notice from the rental provider. If they don't comply with that notice, so the notice will say, please don't keep playing music at 11 o'clock at night. If the person doesn't comply and keeps playing the music, then the rental provider can apply to VCAT for what's called a compliance order. And effectively then VCAT can make a compliance order if it's satisfied that the person has engaged in that conduct, can make a compliance order saying you cannot play music after 11 o'clock at night. If you do, then you can get a notice to vacate issued against you. So it's really a staged process. If you don't comply with the notice, then you can go to VCAT for a compliance order. If you don't comply with the compliance order, you can get a notice to vacate issued. So it's really important that when a breach of duty notice is given, that there's that's something that clients are aware of and understand because of the consequences if they don't comply. So what do you do if someone gets a breach notice? It's really about helping understand the breach and how to remedy it. A lot of people get those notices and don't know what they mean. So it's really important that someone understands that, and then they get help if it's true what's on the breach notice, they get help to comply with it. It's important to look at whether or not it's valid, the notice. So there's things you can do to look at what's valid, and also really looking at whether or not the conduct alleged is something that the person agrees has happened or not. If not, there are avenues for challenging the breach notice. Otherwise, it's really about helping someone to comply with that notice. This is just a quick slide to show you what that notice will look like. So every notice looks quite similar in terms of their look. Oh, sorry, it's skipping over the compliance order slide. Is there someone who can just click me over to the next slide. Thank you. So compliance orders, if a breach notice isn't complied with, like I said, it can go to VCAT for what's called a compliance order. And the compliance order basically just is an order from VCAT that says that, if you don't comply with this order, then a notice to vacate may be issued. As Ben said, it's really important that the compliance orders are as limited as possible. What we find is that they can often be not limited with time, and that can put a lot of pressure on a tenant in terms of their behaviour. Next slide, please. And then finally, as I said, if the compliance order is breached, then a residential provider can issue a notice to vacate for breaching a compliance order. The other option is, if there's been 2 breach of duty notices, then instead of the compliance order, a landlord can actually just issue a notice to vacate at that point. So that's why, if there are any issues coming up around breach notices, and particularly evictions because of them, we really recommend that you refer obviously to us, but to any other CLC to get help with them, because we find they can be quite complex, but also that there's really good ways in which evictions can be prevented. So really encourage for there to be referrals made for these kinds of evictions. I won't go into detail because I've just been through some of this, but the really important thing if you're supporting someone with these breach and compliance issues is really thinking about how to support someone to comply with the breach, if that's an issue, or with the compliance order, and what supports they might need to do that, whether that's mental health, whether that's any other kinds of support. And then also if there's an eviction proceeding, going back to the reasonable and proportionate test we just spoke about, any evidence that you might be able to help the client gather in relation to, why there are supports in place, how their conduct has changed, and the fact that they will comply with their duties. Next slide, please. So finally, family violence provisions. I'll go through these quite briefly because I'm aware of time. So basically, next slide, please. The good news is that there's better family violence provisions now than ever. Basically, they're accessible to someone who's either on the lease, but also someone who's not on the lease. And if it's someone who's been subjected to family violence or is a protected person under a personal safety intervention order. So what can these family violence provisions do? Next slide, please. Basically, they can allow someone to either end their tenancy early without getting lease break costs. So if someone needs to leave their tenancy urgently because of family violence, they can do that and not incur costs. But it also allows someone who's experienced family violence to potentially create a new tenancy in their name. So if they are safe and want to stay in their home, they actually can apply to VCAT for the tenancy agreement to be made in their name only. Which is, a great option if someone is safe to do so. The other exciting thing about these new provisions is that the tribunal can consider what's reasonable in terms of liability for costs. So they can look at that and actually divide it between, if there's a perpetrator and a victim survivor, they can do that. Same in relation to bond, they can determine that liability and split it out. And they can also, there's also better protections in relations to tenancy database listings. So basically, if there's family violence involved, people shouldn't be listed on tenancy databases. And finally, I think as Ben mentioned, there's access to safety modifications, which is a lot better and a lot easier than before. So that's the kind of keys to the new family violence provisions. Next slide, please. The other thing to say just briefly before I finish is that where there's an eviction and it's family violence was involved, there's better protections. So if there was a family violence issue that gave rise to the eviction, then that can be raised with VCAT, and it can also be raised as part of the reasonable and proportionate test. So I won't go on any further because of time, but just to let you know that those family violence provisions are really good, and I think, as Catherine and Ben indicated, VCAT is really committed to hearing those quickly, and there is also a VCAT family violence support worker who can help organise things on their end. So really encourage, if there's family violence involved, please feel free to refer to us and get that help, and just letting people know that there are options is really important. But I'll leave it there and hand over to Damien. Thank you.
Hey everybody, So I am Damien Patterson. I'm the Policy and Advocacy Officer at Council to Homeless Persons, your peak body for homelessness. Today I'm going to be talking a little bit about some of the things you need to know when working with people experiencing homelessness or at risk of it, in terms of finding a home, and also common advocacy that we do on their behalf. I also want to start by recognising the traditional owners of the land on which we're meeting today. It's important when we meet to talk about homelessness that we recognise that this year 1 in 6 Aboriginal and Torres Strait Islander Victorians will experience homelessness. That number is far, far too high, and it continues to be the ongoing work of everybody in this meeting to bring that number down. You've heard already that there are 130 reforms. I will just let you know that they were legislated 2 years ago, and that's when I was most active in the space. So apologies in the Q&A section if I have to say I don't know quite a bit. However, the reforms are really good, and they mean something important for homelessness. They're going to mean fewer evictions. They're going to mean more rights for those who are in tenancies but at risk of homelessness. They're going to mean fewer opportunities for landlords to discriminate. And in the end, these things are going to add up to less homelessness in Victoria. My intention today is to talk a little bit about some of the common touch points for people working with those experiencing homelessness to the RTA, as you can see from my outline here. The blacklists. So people who are evicted from private rental properties or who accrue large debts in them can be listed on the residential tenancy databases, which can be known as blacklists. The very purpose of these blacklists is to keep people out of new rental properties. They create homelessness by doing so, and they funnel people, the most vulnerable people, into rooming houses. A person can only be listed on a blacklist if they have been evicted for a reason where the cause was their own actions, or if they have a certain amount of debt. A listing on a blacklist is supposed to be removed after 3 years. However, the blacklists themselves have not always been super great at removing people once their listing should have expired. People with whom you're working may be getting rejected from properties that you and they felt like were winners after you spoke to real estate agents, or they did. And they may never particularly know why. The answer there might be that they have been blacklisted. The new laws allow people to check if they are on each blacklist once a year for free. As you can see here on the slide, there are a lot of blacklists operating in Victoria. This information on this slide was compiled by Tenants Victoria. You can see their webpage there is linked, and you should consider going to it as it has a lot of advice on working with blacklist operators. I want to talk a little bit about how you can find out about whether a person is blacklisted and what some of your options may be. Getting the information on whether a person is blacklisted won't be particularly easy. You will need to contact each of the blacklist operators, and they are likely to want some significant proof of identification, which, as we know, can be a tricky thing for some of our clients. One of the database operators has up on their website that you can expect a turnaround of about 10 office days once all of the identification is provided. And so there's also that to factor in. That said, should a listing be on the blacklist and should it be unfair, there are new mechanisms to appeal at VCAT, which is great. We can get people removed from the blacklists where their listing is not in compliance with the law. I also want to talk a little bit about rental discrimination. A big reason that people with histories of homelessness are unable to secure a new lease is because of discrimination. It's a really tricky issue to address because agents don't just come out and say that I didn't give you the property because of your race, sexuality, or other protected attribute. And while there is going to be a new statement on the application forms to say that discrimination is not allowable, we actually don't expect that there's going to be a particularly large change in the levels of subvert discrimination for protected attributes. However, we all know that not all discrimination is based on protected attributes under the Equal Opportunity Act. That for a lot of our clients, it's discrimination based on these judgment calls about a person, whether they look like they're going to be trouble, whether they think that they're going to struggle to pay rent. You and I know that troublemakers deserve housing too. And that's why there are some new protections where agents and landlords can't ask questions of applicants that might lead them to prejudice. A lot of the questions that are currently common now will be banned. Have you been involved in a VCAT matter before against your landlord? Have you ever received less than your full amount of bond back? While they can still ask for a bank balance, they can no longer ask for one that hasn't been edited, so you can cross out all transactions. We know from past experience that sometimes agents were making discriminatory decisions based on things like whether you ate takeaway while you were poor or made car repayments while you were poor. Never mind that you may not have a kitchen or maybe living in your car. It is good news for our clients that transaction histories will no longer be the type of thing that can be asked for. If your rental debts are large enough that you can be blacklisted, then you may be on a blacklist, but your agent or landlord can no longer ask if you have a rental debt. Importantly, one of the things that we know is that rooming house operators are setting prices based on which government payment a person is on. That the same room is more expensive for a person on the disability support pension than it is for a person on the job seeker allowance. Rooming house operators are now banned from asking what your income is if they haven't already provided you with the price of the room, which is a great outcome for people who are starting rooming house tenancies. Property conditions. I don't know that I need to repeat that much of what Ben and even Minister have said here. I do have more information available if it comes to that in the question and answer section. However, there is a little bit of new content here as well. An important thing for those working with some of our most vulnerable clients to know is that landlords have a new responsibility, which was mentioned earlier, to conduct safety checks on gas fittings and on smoke alarms. This is a positive thing, but there is also some concern around it, particularly for where a renter isn't willing to allow access to the property. The law doesn't make an exception for the landlord's responsibility if they can't get access. And so if a person who is a renter is unwilling to provide access to the property, say they're having a particularly bad mental health time, and they're not willing to let people in, that can put their tenancy at risk. In some instances, it may be important into the future to help your highly vulnerable clients understand that for the good of their tenancy, they do need to allow access for these checks. Depreciation is another one that we're happy to see. So when an item has been damaged in a rental property, it is not uncommon at the moment for a landlord to try to charge a replacement cost for essentially a new item, where the old item was old, the damaged item was old. It is good to see now that they have to account for depreciation. There is a resource by the Australian Taxation Office that lets you know how quickly an item loses value. For example, a carpet loses all of its value across the course of 8 to 10 years in a rental property. And so renters should not be charged for the replacement of a particularly old carpet. Another item that you probably need to be aware of is a change around, is a new eviction for damaging safety devices. So this is items like smoke detectors in a property. And the reason that I raise this with you is that it is that this eviction also applies to rooming houses. As we know, rooming houses have a requirement that each room be fitted with a smoke detector, and that it is pretty common for those to get damaged by people for a range of reasons, but including as simple as that they wanted to smoke in their bedroom. CHP is concerned that this may lead to a large number of evictions from rooming houses, and it's one that we should all be mindful of when working with our clients in the future. Modifications. Again, this was really ably covered by Ben, and I don't think I need to repeat it. If I run short, then that just means more time for Q&A, which is great. The modifications are quite basic. They are, however, going to be meaningful for people who fear for their safety and people with disabilities. One of the good things is that they have broadened the number of people who can make recommendations on disability modifications to include almost all health practitioners. But once again, if you have questions on that, please let's cover it off that way. But I feel Ben did a great job here. Just on this slide, it is important to note that except for disability modifications, these allowable modifications that I have listed on the slide, they do not apply to rooming houses. This is for general residential tenancies. So that covers off on some of the matters that I know we engage with most as the homelessness sector and as the range of sectors working with people experiencing homelessness. And I hope it was informative, but I'm happy to hand back to Ian now.
Sorry about that. Sorry, everyone. That's going to be the theme of my last 12 months is my mic is muted. Thanks, Damo. Thanks, Sam. Just like to acknowledge all of the work that you and Sam and others have done to make the positive changes. You made a really good point that the changes are really positive. And I was thinking through all of the presentations. There's so much complexity of information, and it just really reinforces to me I guess why it's so important for support workers, one, to be across it, and two, to be able to translate and help the people they're supporting understand how to take advantage of some of those opportunities that Damo noted, and also, of course, to work to prevent evictions. And so I guess I'd like to ask Helen first up about that question, Helen, in terms of, for someone who's been a consumer of community services and had support workers, is it your expectation of them that they're across that sort of information in terms of what you need from them with that sort of detail?
No, I've found my experience has been that they haven't been, because they haven't been given the training to do that. And a lot of them are finding it really difficult to get the knowledge. So what I've been doing is referring them to the ones that I know, like the intake places like Launch Housing and Council for Homeless People, because some of them don't have actually physical officers to do that. So I've tried, and it's one of those things that they say, well, if you're on a NDIS plan, then it has to come under the financial side of that.
Terrific, thanks. I'm just not getting the Slido questions, Karen, but whilst they come up, Neil, if you'd like to introduce yourself, and the sort of question I had for you was, how challenging it is it for support workers to be across that sort of level of detail, and how important do you think it is for them to be across, I guess, the changes to the RTA and tenancy issues in a broader sense? And I don't just mean for homelessness support workers, for any support workers sort of more broadly.
Well, hi everyone. I'm Neil Parker. I work for Launch Housing, which is a large community organisation supporting people who are currently homeless and at risk of becoming homeless. I've done a lot of work with support workers who are their daily job is to support people in housing, to sustain the housing, as well as finding housing of different types: transitional, private rental, head leased properties, community housing. And thinking about housing support workers specifically, yes, it is critical that they are abreast of the changes that are coming through in the RTA. It is a very challenging environment for them because they are working with, a wide range of people with some very complex issues that directly impact on their ability to sustain and maintain housing. So assisting people with living skills in general. Never mind things like paying bills and paying rent and managing the dynamics with their neighbours and all of that kind of stuff. So yeah, very, very important for workers to understand the changes, but also workers outside of housing support, in the psych wards of the hospitals, family violence supports, you name it, right across the board. Yes, it is very important for them to have some kind of awareness of the changes so that they can potentially redirect people to the right place, but also, to try and also get involved and get an understanding of what people are facing in their day-to-day lives that are going to potentially impact on their tenancies.
Thanks, Neil. I should have asked Helen for you to introduce yourself. I've got another follow-up question for you, but if you could just introduce yourself and let people know who you are, I guess.
Sure. I'm Helen. I'm a fairly recent graduate of the Peer Education Support Program. I have experience in different rental accommodations, and also I'm neurodiverse, which means that I have a combination of processing, sensory and learning difficulties. So that's why I've been asked to join today.
Terrific, Helen. And with that, so I'm guessing that a support worker in helping you navigate tenancy issues and issues related to that is important. From a support worker's perspective, from your perspective, what's the best way for that sort of information to be shared with you? What are the key things that support workers need to be aware of, how to get that level of info to clients and consumers?
First of all, I think the important thing is to take the time to get to know the person, because for me, I can get overloaded by information. So it's important for me to get it in manageable chunks and to just write it down simply. I think what happens is you get used to talking in a way that you talk to other colleagues, and a lot of the times I miss out on the important information because my understanding of some of the words may be different. So the other thing is checking in that the person you're talking to understands what you're talking about. And also, if that person needs to have a support person there, then, which I often do, I always try and make appointments where I've got another person and listening for the stuff that I miss.
That's a fantastic point, Helen, about the sort of need to check understanding, because we all sort of tend to say we understand when sometimes we don't, I think. This is a question for Damien. How large does a rental debt need to be placed? How large does the debt need to be placed on a blacklist for a renter?
I didn't come prepared with that information, I'm afraid, and so I will have to provide that after the event. Sorry.
No worries. We'll definitely follow that up. And this one's for Sam. If a perpetrator is the landlord of a home but's not living there and the victim survivor is renting from them, can the locks be changed?
Look, I mean, it depends. Obviously, yes. The family violence provisions cover anyone who is experiencing family violence and is a renter in the property. I guess my only caveat on that would be that, there's real safety issues potentially if you've got that dynamic of the landlord being the perpetrator. So there'd be real questions, I guess, about whether or not it's safe for the person to remain in the property. But the family violence provisions would still apply.
Thanks. This question's for you again, Sam, but also a follow-up question for Neil. What steps would you advise in a situation where a young person with multiple and complex support needs is perpetrating family violence and property damage and incurring costs and rental arrears? That's the question for Sam. And the sort of corollary question, Neil, is how does support look like in a complex situation look like that? What does support for a family or even for the young person involved in that look like? So to you first, Sam.
Yeah, look, and I think it's a great question because I think the reality is we all are dealing with people, who are facing a range of challenges and complexities. And so, what does it look like to help people in those situations? I'm assuming you're saying you want this perpetrator to be able to remain in the property. And if so, what do supports look like? What we find, the most helpful is obviously, the more coordinated the support is, the better. So we have great success where there's programs like J2SI involved, or programs that really are specifically there to support people with a range of complexities and can help coordinate the range of supports that are needed. And I think in that case where there's, issues around a perpetrator and damage, for instance, there's obviously going to be a range of supports needed in terms of the behavioural elements and the violence, but then also really practically around, what kind of brokerage there might be able to be, or other financial assistance, for instance, to help deal with some of the damage as well. And that would show that there's been action taken to remedy the breach. So it's really trying to focus on the behavioural elements and what supports are needed to prevent that behaviour in future, or at least to kind of reduce the impacts of it. But then looking at other more practical forms of assistance you might be able to access that are about, if there's damage to the property or other things that need to be remedied, how you support someone to do that as well.
Terrific. And Neil, any thoughts on that sort of complexity and sort of difficult situation in terms from a support perspective?
Yeah. I mean, this is this is quite a common problem that exists, and we do have a fantastic youth support program, several actually, at Launch Housing. And I have worked closely with that support team in the past in this exact scenario where there was a young male who was wanting to move out of the home. He had quite a few complex needs and was causing a lot of problems in the home with his parents and his siblings, including damage, verbal aggression, violence. And so there's so much that goes into this in terms of, the support, and from my aspect, which was trying to find him the right type of housing for his needs. He was very specific about the type of environment that he wanted, and he was very good at communicating that, which was fantastic. But I think it's such a huge area and it's so difficult to manage, and the supports, if there's no supports in place, I don't know how a family would get through that. So yeah, support is definitely needed, 100%. And luckily for us at Launch, we have fantastic programs. So I would say to anyone out there that's in that scenario is reach out for support. Definitely don't try and handle it yourself. Don't suffer in silence, because it does have life-changing impacts on the whole family, not just the individual.
Thanks, Neil. This is to either Sam or Damien, who either want to take it. A couple of questions that related. How will the new changes affect transitional housing providers that sign clients up to 10 to 13 week leases? And the related question is, with the removal of 120-day notice to vacate, what, if anything, are housing providers able to do if transitional housing tenants are not engaging with their housing workers?
You bet. That sounds like one for me. The 120-day notice is gone. The no reason notice to vacate is gone. That will impact transitional housing providers who will now not be able to provide a no reason notice to vacate. There are alternatives, in fact, a few that come to mind. The first is, of course, as Ben had mentioned, the end of a first fixed term lease is an opportunity for an eviction, should that be what is required. However, it is, I think, apparent to probably everybody on the call that an eviction at the end of a 12 to 13 week transitional housing placement is probably not a great outcome. And so the other two options that make a lot of sense, I guess, are the dedicated transitional housing eviction that exists. And of course, the most preferable one is to manage the tenancy through case management. That when a person finds that a suitable offer has been made that they find suitable, that is the best way to ensure that they move to another property.
Thanks, Damien. We've got time for one more quick question. And just a reminder, I'll be getting all the questions and looking at them, and they'll all be really helpful to inform the CHP work in this space to get some information to homelessness workers. So this one's for Sam. Many of the VCAT decisions will rely heavily on the interpretation of the RTA, the discretion of the member. Will they be undertaking training?
Yes, I don't want to speak for VCAT, but I know that they're really, committed to obviously skilling up the members in relation to this. The other good news is that the reasonable and proportionate test came into play during COVID, so there's some experience already and some case law in relation to that. So certainly, I know that VCAT is doing a lot of work to make sure that they're prepared for these new reforms. And as you say, we're going to have to see how it plays out, and obviously, as it develops, as the case law and the interpretation develops, we'll make sure that we keep the sector apprised, of what it looks like and what it means for people on the ground.
Thanks, Sam. And I'm going to have to wrap it up and thank the panel. So we didn't have time to get to more questions, but we'll definitely look at revisiting these questions and the panel idea. And I'd like to hand back now to Emma from VCOS.
Thank you, Ian, and a huge thank you to the panel as well. It's my absolute pleasure to be giving thanks, but also whilst you're listening to this, but if you wouldn't mind answering the survey that I think will be coming up on your screen at the same time, the event survey that will be on the slide. I would like to sincerely thank Minister Horn, Ben, Catherine, Ian, Damien and Helen, Neil and Sam for what has been a fantastic morning. I think there's been an incredible amount of information that's been shared with what are really profound changes. And as I mentioned earlier today, these are changes that have been advocated for years. So it really is a moment to be, I think, to celebrate the changes, some of which sound like no-brainers and they should have already been there, but make sure that renters know their rights. And on that note as well, if you had a question that you put forward today that we were not able to answer, we will be coming back with that information as well. I do want to also thank all members of our Rental Fairness Stakeholder Reference Group. They have been a driving force behind all of the events that we've been running, so I want to acknowledge them. I do also want to acknowledge a few of the VCOS team that you have not seen today. So Deb Fuster and Karen Taranto, who have just been doing a power of work in the housing and the rental space. I would like to give a particular shout out to Deb and to Karen, and also to Ryan for all things comms and logistical, etc., and making things as smooth as humanly possible behind the scenes as well. We will have a fully transcript and captioned video recording of this event. It will be available in a couple of days, and we will post it to the same webpage as well. And we'll make sure we promote that as far and as wide as we possibly can. We'll send you an email when it's ready. We will chase up the questions we didn't get to today. And please do, if you don't follow VCOS on social media now as well, we'd really encourage you to do that. It's a fantastic way of making sure that you're aware when there's different events happening or sort of different things that happen along the way. And if you get our email alerts, you can make sure that you're aware of any events that are coming up. So I would like to sincerely thank all of you for joining us today for what's been a fantastic event. A huge thank you to all of you who've worked with us to make it happen and for your generosity in being on the panel today. So have a wonderful afternoon, and we hope to see you again soon. Thank you.